Well, I don't know one.
Hmm.
Well, on the last occasion, I was directed to file exception. My lord, it was affirmed on 21st February, but other copies couldn't be prepared for my physical difficulty. I'm praying for adjournment,
Why
and
it is to be mentioned?
with that matter was going on, that on the CSTC matter. Ms. Amal Gandhi Sen was appearing in the matter for CSTC. Some salary areas was to be payable to me.
Your Lordship called for a report whether any amount is due and payable to them or not. So, that report was filed. They were given a chance to file exception to that report.
Now, where is the exception? You have given copy?
I could not get the, but affirmation completed. Kindly, I am very,
Affirmation
has been
completed.
completed on 21st, by duty for my knee problem. I could not complete it, even second copy and also the service copy, even my copy also. The man came from Bankura.
Mr. Mandal, an advocate appearing for the appellant.
The 12th or 17th kind.
Cannot be at your leisure, sir.
My joint
Cannot
knees.
be at your leisure. We kept it to be mentioned for disposal.
Yes,
If
my lord.
you have not taken steps,
No,
for
no,
that,
see, kindly, I have taken steps.
Yes.
For my knee was not functioning, kindly adjourn.
Give the copy, make copies, give it to Mr. Banerjee.
Mr.
We will
Sen
pick
And
it
Mr.
up
Sen
after-
also. By tomorrow I will serve. By tomorrow I will serve.
Next Thursday করে দিন।
I am grateful.
Yes.
My Thursday problem is kindly 7th January. মানে
তো পেশেন্স রাখবে তো।
6 is my problem explaining it.
ইরিটেট করে ছেড়ে দেবে।
7th will
দেখো
be.
হি ইজ লাফিং।
Well, I'm sorry, I have difficult. That is, I'm saying 7th February will be.
The court does not run at your convenience. If it appears on Thursday, ensure your junior mentions.
Grateful.
Monday week করে দাও।
I'm grateful.
Item number 2, I am appearing on behalf of the applicant, mother.
And I appear for the National Medical Commission.
This is a review application, mother. First, mother, grounds of review, mother. Take the grounds of review first. Page number 4 of my application.
ভাইরাল হবে দেখো ওকে তো Yes. Yes.
Mother, may I please? Mother, this order first, mother. 19 November 2024, mother. By this application, mother, I want to revisit the grounds of review, mother. But kindly first, mother, turn page number 4. That is grounds of my review application, mother. Why I am asking for the revisit of the 19 November 2024, my lord's order.
Yes.
May I place, my lord? May I place?
Yeah, just now. How many grounds you have taken? You, before
Four.
placing, you tell us that what is the ground of review.
Malad, grounds of review, Malad, first is Malad, rule of the game change in the midway of the game, Malad. That is the first ground, and that is not considered in the 19 November 2024 Myler's judgment. That's my first contention.
The
And
rule of the game changed.
in the midway of the game.
How?
Well, I just
This was
demonstrate.
not argued before us. First of
But
all,
that was a fact, Malad.
no, if you don't argue, court cannot be held responsible. If you do not argue and new counsels come, now every day new counsel is coming. If you
Malad,
come as a new counsel and say that this was told but it was not taken into, how can we believe you? You were not there at the time.
Malad, whatever is written in the grounds, I can't travel beyond that. Malad, that is written in the grounds, Malad, and Malad, yes, Malad,
Yes.
no doubt about it, Malad. I'm a new counsel, Malad. That's why, Malad, I want to place the grounds. If Malad might
Yes.
accept, might not accept, but beyond pleadings, I can't go anything. Malad, I just place
It
the
is
ground.
not a
That's why, Malad, I
question
want
of
to place the grounds.
acceptance. We are wanting to know what is the ground of.
Yes, that's why, Malad, I want to place the grounds, Malad.
All right.
Page
please.
number 4, Malad. Further, the instant mandamus appeal along with connected application was dismissed pursuant to the order under review on the grounds of doctrine of delay and latches. That the appellant herein had failed to appraise the honorable court the real cause behind such delay in approaching this honorable court. The Directorate of Medical Education, Government of West Bengal issued a memorandum dated 24th July 2023 directing the qualified candidate of NET UG 2023, including the applicant herein, to procure various documents such as domicile certificate, medical certificate, in order to participate in the counseling process for undergraduate medical and dental state quota seat. Such memo dated 24th July, which is very important, my lord. Why he fill up the form on 28th, my lord? He explained it. 24th July 2023 was issued just a day prior to the commencement of the first round of counseling. Here it is pertinent to mention that the procurement, sorry.
রিভিউ অ্যাপ্লিকেশনটা দেয়নি, একটু খুঁজে দাও।
দেখুন এরকম এরকম একটা শর্ট লিস্ট অফ ডেট থাকবে, এরকম হয়তো
একটাই সেট দিয়েছে। এই যে দেখো ক্যান ওয়ানটা দেখো,
ওয়ান্স যদি ক্যান ওয়ানটা পান তাও হয়ে যাবে। ক্যান ওয়ান তাহলে ক্যান ওয়ানটা দিন, দেন মানে আই উইল প্লেস ফ্রম ক্যান ওয়ান ইফ দ্যাট ইজ নট ক্যান ওয়ান পেজ নাম্বার 4 5 it would be.
পেয়েছেন? রিভিউ 372।
এইটা আরো কয়েকটা আরো কয়েকটা আছে মানে পিডিএফটা প্রকাশ করে নিলে যে আরো 3-4টা আনতে বলে এটা কপি, ঠিক আছে? ওই ছেলেটাকে বল, ওই ছেলেটাকে বল, ওই ছেলেটাকে বল, সাবধান বলে ওই ছেলেটাকে বল পিডিএফ করতে নিলে। ওই ছেলেটা ওকে থাকতে বলি তখন।
এটা তো স্টে, এটা মিমোর স্টে তো।
you have not filed 2 copies.
সরি মাদার, পার্ডন।
Separate করে দাও। Yes.
So may I please state, my lord?
You are placing from the memo.
Yes, yes, my lord, ma'am. That's why my memo is written in the grounds is my lord. Page
Yes.
number 4, my lord.
Yes.
Page number 4. I placed it from beginning, my lord. From the
Place it, my brother did not get it.
Yes, then when I placed it from the beginning, my lord. The ground number 1, my lord, on the point of delay and latches, my lord, why he filed the application on the last date on 28th July, my lord, he explained by taking this ground, my lord. I just placed it, my lord. For that, the instant mandamus appeal along with connected application was dismissed pursuant to the order under review on the ground of doctrine of delay and latches, that the appellant herein had failed to apprise the honorable court the real cause behind such delay in approaching this honorable court. The Directorate of Medical Education, Government of West Bengal, issued a memorandum dated 24th July 2023. That is very important date, my lord. Just prior to that date, my lord. 24th July 2023, directing the qualified candidate NET UG 2023, including the applicant herein, to procure various documents such as domicile certificate, medical certificate, in order to participate in the counseling process for undergraduate medical and dental state quota seats. Such memo dated 24th July 2023 was issued just a day prior to the commencement of first round of counseling. Here, it is pertinent to mention that first round of counseling start from on 25th, and it goes up to 28th, my lord. And I fill up the form on 28th, my lord. And that is written in the 19 November order, my lord. I placed it later on the judgment why I take this ground herein. Here it is pertinent to mention that the procurement of domicile certificate and medical certificate took a reasonable amount of time, due to which the applicant herein could only register himself for the first round of counseling on 28th July 2023. So that is my cause of fill up the form on 28th July 2023. It is also pertinent to mention that upon acquiring knowledge of the aforesaid document which were required to be procured, the applicant herein ran from pillar to post to procure the same and ultimately got hold of the same on 27th July 2023, and thereafter registered himself for the first round of counseling process. So I got the document on 27th, that is domicile certificate and medical certificate. That's why in compelling situation, I compelled to fill up the form on 28th, my lord. That is the ground, second ground.
No,
That is on the point.
please pause a moment.
Yes, ma'am.
This ground we took into consideration and we said that you have not ventilated such grievance by making a representation also.
Yes,
It started
that
on
is
25th,
yes.
it ended on
follow.
28th,
I follow.
28th, I think.
Yes,
And
yes, 28th.
This period was wasted disputably for non-furnishing the OTP.
On last date, he fill up the form,
Right.
but he not get the OTP. That is the case. That is his case. On the last date, he fill up the form. Due to technical glitches, he not get the OTP. That is the case altogether. If I understood properly, subject to
Yes,
correction.
but this fact which you are arguing now, that why did I wait till 28th and why did I not get registered on the 25th is due to non-availability of documents. This is your contention.
Yes.
You are saying that this was not taken into consideration by us.
But on the grounds of why, because of that, my lord, why in a judgment, my lord, it is why he fill up the form on the last date, because why he waited for the last date. I want to explain it before, I want to demonstrate it before this court, why I compelling situation, I compelled to fill up the form on last date. That is my compelling situation. I want to demonstrate it, my lord. Second point, and the most relevant grounds, I believe, my lord, that is ground 3. My lord. I place ground 2, thereafter I place the ground 3, one after another, my lord. May I place ground 2?
Yes.
For that, further the applicant herein participate in the subsequent round of counseling for admission in MBBS course with a legitimate expectation that he would be locked in respect of government college based upon his NET UG 2023 rank. Here, it is pertinent to mention that rank obtained by the last empanel candidate under general EWS category in the first round of counseling was 70,000. Now the applicant herein obtained 52,000 rank. So automatically I can within the zone of consideration in the government college in NEET UG 2023 was under legitimate expectation that the cut-off rank for admission to MBBS course would be pushed further higher than 70,000 in the subsequent round of counseling. I participated in the second round of counseling. But to the contrary, the cut-off marks for general EWS candidate decreased to 48,000 approx. Instead of increasing from 70,000. In first round of counseling, it is gone down up to 70,000. But in the second round of counseling, it has gone up to 48,000. Instead of increasing from 70,000. For the aforesaid reason, the applicant herein participate in the subsequent round of counseling. Instead of approaching the competent authority with his grievance immediately after conclusion of the first round of counseling on 28 July 2023. The ground number 3 is most important, according to me, subject to correction, my lord. For the several OBC candidates who had participated in the NEET UG 2023 but could not get a MBBS seat in a government medical college in the first round of counseling were permitted to change their category. It is settled, and as well as it is mentioned, and I got this document from the memorandum of appeal also, that is annexed with the CAN application also, that what is the rule position regarding EWS, regarding category changes. And not only that, my lord, category changes is not permissible, which is also mentioned in their information bulletin also. They can't change any information. May I place
last line we didn't follow.
My lord, suppose, my lord, in a counseling process, a person fill up the form. Suppose I place my category as a OBC category candidate. I can't alter from OBC to EWS category or OBC to SC category. I can't alter it. And that is the rule position. And that is also mentioned in the information bulletin also. You can't alter, you can't modify, you never touch that information. That is the rule position. But what happened in the meanwhile, by the dint of a memo, government memo, the authority give them opportunity by violating the information bulletin, the settled principle of law. You can't change the rule of the game in the midway of the game. They change it. That is the, I believe, that is, and that is very important. Kindly, I place it. Change their category in the registration form. VDA memo dated 9th August 2023. After the first round of counseling, my lord. That is very important. So, VDA government memo, the person who ought not to come within the zone of consideration in EWS category, by the dint of that memo, they altered their category, they get that opportunity, and they come within the zone of consideration in the EWS category.
Did you make him a party?
My lord,
the person who has been illegally...
I gone through this brief, my lord. I got 3 by amendment. The respondent number 8, 9, and 10.
ও যে র্যাঙ্ক পেয়েছে তার থেকে ডেসার র্যাঙ্কের লোককে না সেটা আমরা বলেছি তোমার অ্যাপ্লিকেশনটা ফার্স্ট কাউন্সিলিং এ যদি তুমি পেতে তাহলে এই প্রবলেমটা হতো।
I got this. Sorry.
This point has never been raised either in the petition or in the memo of appeal.
My lord,
This point which you are now taking, that illegally they have changed, they have allowed the some parts candidate to change their category. That point has never agitated. Appeal means not a
yes, and I follow. My lord. Yes.
Before the calcula.
I follow. If that is not canvassed before the court, how could know? I follow. But my lord, I gone through this brief. When I gone through this brief, whether this point is agitated or not, but I got it that yes, that point is agitated here. May kindly, I want to request this court, my lord, kindly take this CAN application, my lord, stay application in memo.
Challenge his appointment.
My lord,
to make him party, all those
yes,
persons.
some of them are in party. My lord, in review
EWS
application also, my lord, some of them are party, my lord. I believe that Afsana Khatun, Resma Sultana, Shomik Ghosh, they are party.
First of all, this was not the
claiming that the candidate of belonging to such and such category, which
Yes.
your
OBC
client belong,
category.
a lesser mark of that category has been given chance.
My lord, my
Uh,
bone of contention is that, my lord, through an authoritative notification, my lord, kindly, my lord, my lord, subject to
Mr.
correction.
Ahmed,
Shamim.
gentleman was appearing in person. Repeated opportunities were given when no
I
lawyer
don't-
was appearing. No lawyer was appearing.
Yes, that's why.
Kept ourselves reserved.
Yes, yes, yes.
Since he is appearing, he does not know the legal
Illegality of, yes, yes, I follow, I follow.
So we insisted that you come with an advocate.
Yes, yes, I follow, I
We
follow.
gave time. The person came. Person argued.
Yes,
We delivered a judgment.
yes, yes. That's why, my lord, that's why, my lord, whether this is.
Yes, all right. What is your next
Yes,
ground, Mr.?
my lord, kindly before that, my lord, whether that is in the record or not, whether it is placed or not,
Come
I
to your
don't.
next ground.
My lord,
Next,
before,
submitted that OBC candidates who converted to general EWS.
yes, yes,
Next line.
yes,
Were
yes.
all possessing EWS such a way who could have permitted to appear in the counseling only in respect of such quota seats.
Yes.
Now, please come to paragraph 13 of the judgment.
Yes.
Come to the last 5 lines. Having not appeared in the first round of counseling, the appellant cannot even challenge the admission of other EWS category candidate in any government venue who may have obtained lesser rank than him in NEET.
But with the best of respect, subject to
So
correction.
you have to prefer appeal against our order.
My lord, I follow, my lord, but my lord, I follow, my lord, in other way,
You're
my lord.
helpless, Mr. Ahmed.
My lord,
We had enough sympathy for this person,
yes, my lord,
but we
I
were
follow, I
helpless.
follow, I follow.
The process, the manner in which they were raising the points, because many
follow.
factors are inextricably bound.
Yes, 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 yes. Bound by the law, bound by the law.
No, due to not appearing in that counseling,
Yes. You missed the bus.
his entire life was wasted.
Yes, yes, you missed the bus.
Now he was considering his humanitarian issue. One government officer granted him leave to study in a private college. That was also argued.
My lord, with greatest of respect, may I place this case in another way, my lord? Just in my way, my lord. I try to, my lord, due to, my lord, why I place this, I thought this is the best ground. Why? Due to, my lord, administrative action. My lord, kindly follow it. On 9th August 2023, by the dint of that notification, I not challenge whether they are permissible. By the dint of that notification, government notification, 9th August 2023, government notification, I challenge the authoritative action, my lord. Kindly follow it, my lord.
Did you challenge 9th August
My lord,
23?
my lord, with greatest of fairness, my lord, it is not challenged, my lord. In it, my lord, it is fact. But the fact is remains fact. I argue before a constitutional court, my lord, and my lord, I bow down before this court, my lord, with this manner and fashion, my lord. My lord, due to administrative action, my lord, which is not permissible, some candidate got a pathway, lesser meritorious candidate, even which is not permissible under the required statute, my lord, they got pathway for getting admission in MBBS course, my lord. So I challenge it, my lord, administrative action, my lord. That administrative action is not permissible. My respectful submission in this regard, my lord, in the review application, my lord, which is not
It
considered.
occurred when you prepared the writ petition as well as when you prepared.
Yes, I
this
follow.
appeal.
I follow.
So it is cannot be stated to be discovery a new and important matter.
My lord,
Now the only point is the error apparent from the face
case
of
of
record.
record.
Only point. Now only point you are saying that you opted to send the logging or such and such on the last date before the day before the commencement of the counseling. They asked to procure certain documents.
Yes, domicile
And
certificate.
you time to procure such documents.
Because these were
And
administrative
hence
reasons.
you on the last date you log in and try to obtain the OTP. But the OTP did not send to you. It was your case
Yes, my lord.
That point was agitated before us. And that point has been raised and decided.
Yes, my lord, I follow.
Whether
but-
it can be agitated,
Yes, yes.
re-agitated in review or not.
Yes, yes. But my respectful submission is that, my lord, that 9th August 2023's memo, that is not considered because due to that is an administrative action, my lord. Kindly, my lord, that is an administrative action, my lord. My best point lies herein, my lord. Whether who might accept, court might not accept, my lord. But my best point in this matter, my lord, 9th August 2020, through by the dint of that notification, my lord, some candidate get a pathway.
Have you annexed that notification?
My lord, even
9th August?
not annexed with this review application also, it is stated, my lord. I got it. That's my lord. Impediment, my lord. If my lord permit, my lord, I can arrange it and the way of supplementary give an opportunity, my lord. Because
If go to Supreme Court, anything can be done, Supreme Court will.
yes, I got a judgment also, but my lord, but
Supreme Court in that sort of matters.
next year, my lord,
consider-
I came with a judgment, my lord.
It
It is
is an
similar type of case, my lord, in MS admission, my lord. And the next year, Supreme Court gave the opportunity and medical council.
Why do we say so, Mr. Ahmed? Because of this reason, that Supreme Court itself has passed order that after this tenure is over, question of admission will not arise, no matter what happens.
But
No
separate-
matter what happens.
I want to, my lord, I want to.
So you should go to the Supreme Court
my-
and on humanitarian ground you should make this prayer. Because we are bound by the rules and regulations.
May I take, my lord, some time, my lord? Because of that, I want to place a judgment, nothing else, my lord. And I believe, my lord, it's subject to correction, my lord. Supreme Court not enjoy extra power, my lord. X7, except 142, Article 142, my lord. But my fact is that, my lord, in the similar type of
142 will
situation,
apply.
yes, great power, but not now, which is not permissible under law. Supreme Court never.
So
But
you try and challenge our order
yes.
before the Supreme.
my lord, may I take
You challenge
some
both of our order, that the order which we passed,
review? Obviously, I have to. But my
after
lord,
considering your submissions when we pass the order in review, you challenge both the orders to the Supreme.
my lord, may I place in this manner?
You tell us how we can help your client. You tell us.
My lord, that's why I want to show a Supreme Court judgment in this regard, my lord.
Years have already gone.
Yes, in this situation, what Supreme Court gave the solution, that's why I bring this judgment.
That only Supreme Court can do. We
Well,
cannot.
this order not under Article 142. Well, kindly take for my satisfaction. Sorry, 21 14 SCC 805 দিয়েছি তো দেখুন তো 22 14 SCC 805 ওকে মানে কোনো দাগ দেন 2021 14 SCC 805 National Medical Commission versus তোমরা এই এটা প্রেফার
Yes.
may I para 1 to 6 I place it, give some time because similar type of situation and Supreme Court gave the admission in the next year, my lord. So that's why, my lord, I place this. And he missed the last date also, my lord.
No, before placing, we want to know what is the relevance of this judgment in review.
My lord, no relevance, because my lord wants a pathway. That's why, my lord, I wants to, my lord, demonstrate it
Which
because
paragraph you have
the
placed?
relevant paragraph is the last paragraph, the para 16 and 17, because of the next year give a admission, my lord, the relevant paragraph. But what was the fact, my lord? I want to place it from paragraph 1 to 6, my lord. What was the fact in this case, my lord? Aggrieved by the denial of admission to first year postgraduate medical specialty course of MS, general surgery.
Huh?
Para 1 to 6 and 16, 17.
Yes.
And my path, I want to search the pathway. That's why, my lord, this was aggrieved by the denial of admission to first year postgraduate medical specialty course of MS, general surgery for the academic year 2020 to 2021. Respondent 1 filed a writ petition in the High Court of Judicature of Hyderabad for the state of Telangana. The High Court allowed the writ petition and directed the appellant National Medical Commission, Medical Council of India to create or sanction one seat in MS General Surgery. So High Court give this order. A further direction was given to respondent to such and such institute, Hyderabad, to grant admission to respondent 1 in MS Medical Surgery, General Surgery course. The judgment of High Court is challenged in above appeal. Medical Council challenged this, National Medical Commission challenged before the Supreme Court. Respondent 1 passed the final year MBBS examination in January 2019. She completed 1 year compulsory rotary internship as a resident intern from such and such date to such and such date at Malla Reddy such and such hospital. Thereafter, she was awarded Bachelor of Medicine and Bachelor of Surgery degree on such and such date. In the meanwhile, she appeared in the All India National Eligibility Cum Entrance Test NEET Medical PG Entrance Examination 2020 on 5th January 2020. She secured All India rank 93,563 with 327 marks in the NET examination for admission into postgraduate medical course. Respondent 1 was called for counseling and was given provisional admission to the MS General Surgery course in the mop-up phase 3 on the 28th July 2020 and was allotted to Respondent 2 college under management quota. According to the provisional allotment order, Respondent 1 was required to report before the principal of Respondent 2 college by 4 p.m. on 30 July 2020. In case of failure to report before Respondent 2 college within the prescribed time, the provisional selection of Respondent 1 shall be automatically cancelled. According to Respondent 1, she appeared Respondent 2 college along with her father on 29th July 2020 and 30 July 2020 for submission of certificate and payment of tuition fee as well as college fees. In spite of her presence in Respondent 2 college, the admission of Respondent 1 was not completed. On 30 July 2020, the last date for admission into postgraduate medical course was extended till 30 August 2020. Pursuant to the direction issued by this court, Respondent 1 made an attempt to meet the chairman of Respondent 2 college on such and such date. However, she was not permitted to meet the chairman. Having left with no other alternative, Respondent 1 filed a writ petition for seeking a declaration that denial of admission to her in the postgraduate medical course for the academic year 2020 to 2021 as illegal. Respondent 1 all sought a direction to Respondent 2 college to grant admission in MS General Surgery. Respondent 2 college filed a counter in the writ petition in which it was stated that the university constituted a committee for verification of original certificate and students who were allotted provisional admission by the university were directed to approach the said committee for the purpose of verification and original certificate. Respondent 2 college denied that Respondent 1 approaches the college for admission on such and such date or such and such date, that is last date. In the next sentence, Respondent 2 college averred that Respondent 1 and her father visited the college on 29 July 2021 only for the purpose of inquiring about the admission procedure and the requisite fee. As Respondent 1 did not avail the opportunity of admission, Respondent 2 college contended that Respondent 5 was given admission on 11th August 2020. By its judgment dated 18th September 2020, a division bench of the High Court allowed the writ petition and directed the appellant to create a seat in MS General Surgery and to grant admission to Respondent 1. The High Court disbelieved that statement of Respondent 2 college that Respondent 1 did not approach the college either on such and such date and such a that is last date. The admission granted to Respondent 5, who is 2000 rank below Respondent 1 on 11th August 2020, was found fault with by the High Court. As Respondent 1 was illegally denied admission by Respondent 2 college, the High Court directed creation of a seat and to grant admission in MS General Surgery to her. Admission that was granted to Respondent 5 was not interfered with, as he might have been an innocent party unaware of the circumstances in which seat was denied to Respondent 1 by Respondent 2 college. The appellant is mainly aggrieved. The appellant means medical counsel. The appellant is mainly aggrieved by the direction given by the High Court to create or sanction an additional seat in postgraduate medical, especially course of MS General Surgery for academic year 2020 and 2022. So they were aggrieved, medical counsel. And what was the Supreme Court solution, that is para 17. Yes.
Yes.
Para 17, my lord. Respondent 2 college adopt unfair means to deprive respondent 1 admission to postgraduate course. Respondent 1 has lost one previous academic year for no fault of her, for which she has to be compensated by way of an amount of rupees 10 lakh to be paid by respondent to college within a period of 4 weeks from today. Furthermore, respondent 1 is entitled for admission to the MS General Surgery course in the next academic year 2021 to 2022 and shall be given admission in a seat allocated to respondent to college. In other words, one seat in MS General Surgery course from the management quota of respondent 2 college for the next academic year shall be granted to respondent 1. So, Supreme Court, my lord, when High Court create a seat and give a seat to the petitioner, Supreme Court upheld it and give a seat to him. That's my only ray of hope, my lord. I believe, my lord, in this case also, because he came within the zone of consideration. His rank is 52,000. In the first round of counseling, this goes up to 70,000. My respectful submission, my lord, because he unable to give the tuition fees of my lord, private medical college. That's the case, because he belongs to EWS category candidate, my lord. He's the only ray of hope, my lord, in the very next year, my lord, if possible, because it is upheld by the Supreme Court, my lord. I believe, my lord,
Actually, this judgment cannot be stated to be ratio residence.
nah, I just want to cite it to
Decision.
in a decision, and that is upheld. Yes.
At that part here, the petitioner came with an allegation that the OTP has not been sent as it was required to be sent.
Yes,
As
that
per
is
the-
technical glitch.
But that he has failed to substantiate such claim. Only on 28, I cannot recollect, 28. he made an
28, yes,
attempt.
yes.
Ah,
My lord,
28
correct.
made an attempt. But on subsequent occasion, at the second round of counseling, he made repeated attempt.
Yes.
And without raising any issue, he joined in the second round of
Yes. I follow. Only point is
Now,
advocate letters.
advocate letter.
Yes. I
Now,
follow.
2 years has already been left. Now the future post is meant for the future student.
Yes.
Now he has already lost 2 years.
My lord, may
He has occupied one seat in the private medical college. That college is not being utilized, that seat.
Yes. I follow. But
That seat. Now in government college, already 2 years or now 3 years is already going on.
I follow.
He has not read.
Yes.
That means one college from 3 years back, we have to reserve
My
for
lord,
him.
may I put this case in another way?
Finding any fault of the authority concerned.
Yes, my lord, there is a
Order some document that this message was sent.
my lord, may I place case in this?
No, when you received the OTP on 28th, why didn't you go? In the 9:48 in the morning hours, you received the OTP.
I know.
Then also it was open. You wasted and you went to participate in the second counseling. That is the fact, na? He did not register himself in the first round of counseling because though he obtained the OTP
But
at 9 hours.
He
Huh?
claims that the OTP I did not receive.
No, he received subsequently.
Subsequent. Yes.
That was on the last date of counseling, but still he did not go and register himself. Is this the fact?
No.
Possibly,
That is
possibly what happened is
I just
he
taking.
claims, Malad, that he applied for OTP. The record of the medical counseling committee shows that the OTP was generated. He says that I did not receive.
Yes.
He says that I did not. But the record of the medical counseling committee, Malad, your lordship will remember,
No,
Mr.
when he made
Yeah,
the second attempt, he was given the OTP on 28th July. That appears from the order, our order.
Your lordship's order, yes.
Please come to paragraph 12. The photostat copy of the log obtained from the server of NIC as annex such and such of the AO would reveal that though the first round of the commenced on 25th July, the appellant fetched the ATP only once, and that too on the last date of the said council. On
Yes.
28th, in
On
response there
28th
to
at
OTP,
9:48.
OTP was sent to his
But
number.
not delivered, but I not take it.
Yes, that is the problem.
Yes.
Now, after that, you went for second counseling. At that juncture, if you could have come.
Yes, technical glitch.
Yes,
yeah,
but you came after 2 years.
no,
2 years or
no.
1 year.
No, my lord, my writ petition filed on
After everything was complete. You have taken admission
Admission
in a private.
no, my lord, my writ petition filed on 5th October 2023, my lord. As the record
October, that is how many months?
You are admitted. On that date, you are admitted.
2023, no, my lord, deepest respect. That's the
Where
record shows. My lord, on that year, my lord,
But
not
kindly consider this.
Page number
Where of the writ
160.
petition is migration,
46.
nothing else.
We have
46.
said that writ petition was affirmed 15 days thereafter on 5th of October
Yes,
2020.
that's
We
2020.
considered that fact.
But my lord, my respectful submission is that, my lord, 15 days is not so delay. But suppose, my lord, a
That
candidate.
is why appeal. We thought that in this fact situation, it cannot be done. So instead of wasting your time here, you should have gone up in appeal, then
I follow,
citing this judgment. And this is also facts are different.
Yes,
Herein-
obviously.
Herein 2 dates, the person went with his father.
Yes.
College kept him sitting. They did not receive thereafter they received the money.
My lord,
Then also they denied.
may I put my case in another way, my lord? Just bear me
Yeah.
some time, my lord.
We have heard you, Mr.
Yes, as my lord deems. ঠিক আছে।
আরে স্যার বসুন।
আমি আসছি।
Too much chance there. You want to say any other thing?
My lord,
We will not stop you because it is of a person who had the quality,
I tried to-
eligibility.
yes, I try. That's why, my lord, I try myself. The best point I can agitate, my lord, and I thought of that, my lord. Ground 3 is the best point which never been agitated, my lord.
Agreed
But
by
this is
the-
an administrative action, my lord.
Yes.
That's that, my lord. Kindly consider on that, which is not permissible.
Agreed by
but
the
not-
judgment dated 19th November 2024.
Yeah.
আরেকটা কে শীর্ষান ও কাদের হয়ে
Mr. Bandyopadhyay was appearing for the medical counseling committee.
কি বলবেন তো
MCC, Medical Council.
any junior office is here
I-
you are there your senior has come to court
Yes, my lord.
you know that
Yes, my lord.
দিয়ে দাও
My
Yes.
lord, he is
I'm
appearing in court number 26.
so we are happy to learn that which court he is arguing
In court number 26.
so division wins
Yes, my lord.
oh acha. Please tell him that we are very happy to learn that he is in court and we took the trouble of incorporating his name. What is your name, madam?
My lord, Riya Noshkul.
হ্যাঁ
Riya Noshkul.
এই ওনার নামটাও দিয়ে দেবে your name will also be there
But I am not in the panel, my lord.
Okay.
doesn't matter we are recording your name
My lord, I'm extremely grateful, my lord, for patience hearing, my lord.
Hmm.
Extremely grateful. I'm extremely grateful, my lord.
yes
Lordship, I am appearing on behalf of the respondent, Union of India and CIS of your Lordship.
who is the petitioner
Petitioner Lord Singh,
you are there restoration
restoration.
and what are those two applications can 2 and can 3
Lordship, one is restoration and one is section 5, your Lordship, 188 days delay.
you want to oppose that
Lordship, 188 days delay, your Lordship, and they have not submitted in this application that the, due to that reason, nothing.
take it up tomorrow
Lord.
if you can please give an intimation if you can
Lord,
yes next
Lord, beg to appear for the petition.
expeditious hearing
No, my lord. My lord, this is an order challenging the order passed by the learned tribunal in a contempt application, my lord.
এই রে
Punishment or
No, my lord. May I state the facts for a moment, my lord?
punishment or contempt application was dropped or
No, my lord.
please show us the order first
Yes. My lord, page 66 onwards, my lord.
চার্জ ফুল হয়ে রয়েছে না হচ্ছে না চার্জ থাকুক চালাই ইয়েস
Page 66 onward. May I place the brief facts of the
এক সেকেন্ড দেখে নিন পেজ 66 judgment of 5th August 2022
Yes,
when did you file the writ petition
my lord? This is my lord. My lord, this was filed in the year 2020.
রয়েছে হ্যাঁ, ওর কিছু
2022 only it was filed, my lord.
2022 any pending applications are there no
No, my lord.
that was hard upon affidavits
No, my lord, not upon affidavits, my lord. My lord, what happened, my lord? I missed a page, a relevant page, so I filed a supplementary to that regard, my lord. I have already filed, my lord. That is on record, my lord.
no very good now all applications have been disposed of
My lord, this is contempt is still pending, my lord.
you have filed this challenging 5th September
My
order there are private respondents also
Man, there are no private respondents, my lord. There are only state respondents.
where is your contempt application before the tribunal You have filed the WPLRT. You have added these persons
My lord, the
or legal heirs.
my
Very
legal
good.
heirs, my lord.
Now you have not implemented the contemners. Contemners must be by name.
Yes, my lord.
That you have not implemented.
No, my lord, that has not been. But from the
You know contempt application. In the contempt application, you must have implemented them
yes, my lord, in the contempt application they are implemented
with name.
with name.
So then why didn't you implement them here? Mister, they will be appearing for the authority, but contempt is not, you are alleging contempt against a particular gentleman.
Yes, my lord. My lord, what I am on, my lord, just my lord, may I place the brief? My lord, during the pendency of the
The date was fixed on 16/12/2022.
yes, my lord.
Now we are in 2025.
My lord, still
What happened in the
my
meantime?
lord, nothing, my lord. Since
No order has been
no,
passed.
my lord, since it is pending before your lordships, my lord, before the Honorable High Court, so it is kept at abeyance, my lord.
You also did not take any step.
No, my
You are
lord, it
also
was hard,
seeking
my
to
lord, on the 2-3 occasions, my lord.
direct the BLRO to start a fresh proceeding.
Yes.
My lord, that is what I am on, my lord. My lord, the contempt during. Or may I state the brief facts, my lord? But in short, I'm
Was the order ordering portion, operative portion of the order, alleging violation of which contempt application was filed.
during the contempt application, there were 2 sets of order. One that was supplied to me from the office of the BLRO, which stated that this has been done in your favor, that there was inherent mistake on our part. But during the contempt proceeding, a different set of order was produced before the tribunal, my lord.
Very good. Then what did the
The
tribunal say?
tribunal set aside both the orders.
And my lord, direct the authority to pass the order fresh.
Then this order has not yet been passed since it is pending.
As because my lord, he filed this application before this honorable High
So
Court.
your
My lord.
BLRO
So
went
your
to sleep.
my lord, and filed an application on the previous occasion, another case, my lord. Then filed an application that we have already filed an application under 226 before the honorable High Court, my lord. So your lordship.
So you are not agreeable that a fresh decision is
No,
to be
my
taken.
lord, the reasoning that has been given, my lord, in their reply, my lord, against the said compliance report that was filed before the tribunal, we filed an exception. They have filed a reply. In the said reply, the contemptor has stated that I had heard the matter on that particular date, and then I have kept it pending. Later on, I have passed my order, my lord. But if we keep both the orders side by side, it tells a different story, my lord.
Now both have been set aside.
My lord,
Yes,
this order, my lord, which has been supplied to me from the office of the BL and LRO, that was never under challenge. This order has also been set aside.
That is in your favor.
Yes.
So what was their contention?
Well, may I kindly takes up the supplementary affidavit, my lord.
How can we take up? You have to first you have to remove the defects.
My lord, may I?
For 3 years you have not removed the defects. That is why we wanted to see the contempt application.
My lord, may I implead the contemptor here and now, and I will file
I
the.
don't know where is the contempt application. And do you know who are the persons who are now holding the post?
Yes, my lord.
You know.
Yes, ma'am.
So very good. You show us from the contempt that they were implemented. How could you have filed a writ petition? This is an against
Ma'am,
an order of
order-
passed in contempt.
Yes, my lord.
So the contempt, see you contempt মনে হয় করে এই যে দেখো bring the contempt application.
Fine.
Next Thursday. Yes, next.
I appear for the respondents. Status.
Well, earlier request, your lordship was pleased to
order হয়েছে?
direction to take instance.
ये इंस्ट्रक्शन कॉपी दर्शक को दिए थी
কপি একটা কপি
আর কপি আছে
না স্যার চারটেই কপি ছিল
একটা ওনাকে দিতে হবে
আর নেই
তোমার কাছে কপি
এটা
নেই
একটা স্ক্যান কপি প্রিন্টটা নিয়েছিলাম ভীষণ ঝাপসা
বাহ
কি হবে
Yes, Mr. Pardy.
Well,
What's the
I have just received now.
key?
I was
This,
direct-
well,
on the
this
last
instruction.
occasion, my lord, subject to correction, your lordship had directed me to take instructions in the matter, my lord. I've just
Yes. Key instruction. দেখেন
আরেকটা কপি দর্শককে দিয়ে দিন না, ওখানে রাখা আছে না বাইরে
ও
ওখানে
আচ্ছা। So, Mr. Pahadi, why you are wasting your time? Go and file a fresh original application.
We cannot.
Impeding
lordship-
nobody.
No, your lordship kindly see the
Legal
order
matter.
earlier passed.
Huh?
Earlier passed this order.
Earlier?
Earlier BLRO passed this order in this respect. By opening, by initiating a case. Lordship kindly page 21. BLR himself said that there is no Borgadar.
There is no?
No Borgadar.
No Borgadar.
No border.
No Borgadar,
No
yes. There is no Borgadar. It has been ascertained
What is
by
your
inquiry.
instruction,
So
Mr.
I am
Pahadi?
made representation.
My instruction says, my lord, that a Bhakchas proceeding was initiated, my lord, under section 20B was initiated where it was not ascertained whether the recording of Borgadar could be deleted or not.
Borgadar, they said that there is no Borgadar.
Under
We
section,
said
under
that
section
it will be
20B
deleted.
of the Land Reforms Act,
Okay, due to impediment of a necessary party according to the Borgadar, according to the tribunal, this original application has been dismissed. We can give that dismissal will not preclude him from preparing
Grateful.
further OA application impeding the left out.
Left out, it has been decided there is no such persons.
Very
No
good.
such persons is there. Why, your lordship kindly see the order.
No legal heirs of Mubarak.
No legal years. It has been decided by this BLRO.
that is
Notice was served, issued, circulated. Pradhan said that the report was called for, and they said there is nobody is there.
So if this fact has not been brought to the notice of the tribunal.
Yes, I have stated in the tribunal. I have enclosed the notice. I have enclosed the entire order. My lord, on the submission of the learned, my lord, state advocate, the order was passed without going through the records.
BLRO.
How could I implead? I could not implead if there is nobody is
Which
there. I
portion-
could not
which
implead.
portion you are showing?
My lord, your lordship,
Page
total.
21,
Page
if a-
21.
21, if your lordship says, my lord, it is very clear there is no legal error.
There
Second
is-
paragraph.
Second paragraph.
It is observed, my lord, that the local Gram Pradhan issued a certificate to the effect that opposite party Borgadar died long ago and no legal heir also remains of the locality.
Local.
DP's certificate is with case record. On scrutiny of record, it is witnessed that the Borgadar's name has not been
Found anywhere.
noted.
And lastly, they said that the input that
Oh, he
there
was-
is no. In view of the, I am satisfied that Suitland has been cultivated a person personally. There is no Borgadar in this land. Your lordship kindly see page 22. Two proceedings was initiated, two proceedings were disposed of. Finally.
Now they are.
We made representation 25 that my lord, in terms
20?
of the my lord, order passed by VC case number
What is
such and
page
such.
23, Mr. Pahadi?
My lord. 20, 22, 23. My lord, two proceedings was initiated. Two proceedings against the two Borgadars. Two different proceedings was initiated against the two different Borgadars.
For what?
For
Cancellation?
cancellation, no. There is one, we said that there is no Borgadar. So, 20B, my lord, application was filed. Let it be deleted from the record of rights. Names to be deleted in the record of rights.
Land reforms to the. So this proceeding was on the basis of a 20B application
20B
made by you.
20B application under the Land Reforms Act, my lord. He prayed for deletion of the name of the Bargadar because there is no Bargadar. And he says, my lord, he was personally cultivating the land, though under the law he could not have
Very
done so.
Then
My lord, this order was passed in 26th August 1991. My lord, this order was not being implemented. So
And
he
no
made,
appeal was-
he
no
made a
appeal was-
he made a representation, my lord, in 2023.
25.
23, my
no,
lord, he made
this
that.
order is not being implemented means nobody's name is there as Borgadar.
In the
Nobody
record of
there.
rights, the name of Bargadar is there.
Record of rights, well, it
Name
has
of-
been
the name
there.
of
So
Bargadar is there.
we made application to delete it in terms of the order passed.
1991,
case number,
my lord, this
Sergeant, sir.
order was passed in 20B proceeding. In 2023, my lord, he made a representation and thereafter he went up before the learned tribunal. In my humble submission, my lord, this order should be set aside, my lord, remanded back to the learned tribunal because when there is no Bargadar and is legal heir, so there is no question of implement of any party. Subject to correction by my lord.
So after these orders were passed, you made a representation.
Yes,
Yes,
my lord.
yes.
Page
Page 25.
after, my lord,
This you filed after
My lord, my lord.
12 years.
My lord,
23,
these order
nine.
which was passed,
my
my
lord,
lord,
23 and 9,
it
31
is
years.
comes to its finality.
After 31 years.
It comes to its finality,
So Mr. Pahari,
my lord.
your disposal
there-
was in 91.
My lord, there is no such thing. My lordship.
91 was your disposal.
My lord.
Now how you have waited till 2023? How you will explain
My lord,
this?
it is my lord. Sometimes, my lord, I am saying, just record shows time to time that my lord, names of Borgadar is not deleted. So we thought that the order was already passed, so it to be automatically deleted. So that's why, my lord, we made delete. And it comes to its finality, no appeal against
Where
this
is
order.
your application for deletion of Borgadarshi? Where is that
My
application?
lord,
Have you annexed?
It is not annexed.
it is not annexed.
ওটা ছাড়া সব annex করে রয়েছে।
My lord, we have, my lord, what, my lord, records I have, my lord, got, we have interest. We are not suppressing. We are not suppressing anything, my lord.
The plot number,
825.
Plot number, my lord, your lordship, kindly read it.
25 and 831.
831, your lordship 21, last para, your lordship kindly see.
831 by 3439.
3439.
আর 825
825.
Yes.
From whom the Batada
Borgada.
Batada was made,
Hmm.
that is under Borgada.
My lord, this was the challenge. My lord, there is no Borgada, despite, my lord, records found that there is, my lord, Borgada.
There are two plots.
Two plots, I mean, two case was initiated.
Page 26, Sheikh Sarbucks, who is Sheikh Sarbucks?
My lord, that is, my lord, Borgada. Name of the Borgada.
Name of the Borgada Sheikh Mubarak.
Mubarak Ali.
Mubarak.
Mubarak Ali.
Died living
Mubarak
in
Ali.
Portugal.
Mubarak Ali.
Mubarak Ali.
Mubarak died living behind no, but you come to page 12, the written instruction. You hand over a copy.
No, I have not gone through it.
I have
my lord,
not.
now. Just got it.
831 by 34.
Just I got it. My lord, I have to verify it.
825, 34.
In plot number 831 by 3439, Sheikh Sher Box
Have one share box.
was recorded by Bargadar.
Share box is coming.
That is my share box.
এইটা এখানে দাও
হ্যাঁ।
ওখানে নেই
No, you said you filed two applications.
Two applications.
One was
Against two Borgadas.
who are those Borgadars?
That is, my lord, recorded
If
here.
your lordship kindly sees page 20, my lord.
20.
Page 20 is the
Page
record of
20,
rights.
Borgada.
Tag,
Mubarak.
tag number, my lord, 825 and 831, Borgadong, Sheikh
And-
Mubarak, and this
other
one is Sheikh Sher Box.
Share box.
Share box.
Who is
Share box, my lord, that is my proceedings.
34.
That is my 23. Two proceedings, 23.
application করেছে।
My lord,
Two
if
applications.
your lordship kindly sees page 21,
21 and
is-
23.
21 is regarding, my lord, plot number 831. Has your lordship got page 21, my lord? Plot 831, second last line.
Yes.
Plot number 831 and page 23, my lord, plot number 825. In the third line of the last paragraph.
ঠিক
ঠিক আছে?
ঠিক আছে।
একদম
825 by 3435.
3435.
And
Here,
that
my lord,
was 3439.
and the other one is 831 by 3439, which is at page 21. Second
Now,
last line.
Here also they have named Mubarak. See, he transferred petitioner purchase, and since then he has been possessing land by personal on verification. And it appears that one Mubarak.
কোথায় কোনটা লিখেছে
So this has to be Sherbugs then. Right? No?
My lord, no, my lord, in subject to correction in page 21, the Borgada's name is not Sheikh Sherbox. Sherbox.
5/3435.
হুম,
Classification of the land is Jol. It is not which Purva Mednipur. Whether
Right.
Purva Mednipur,
It is
the
Jol.
low land is classified as Jol.
রেকর্ড সুট জল মানে ল্যান্ড মাইনাস যেখানে কাজ
Pond, maybe pond.
Pond.
No.
Right.
Pond.
Jol.
Pond.
Consider
হ্যাঁ,
করতে বলে দাও। কি দরকার? যে
Okay,
বর্গাদারের ওই
My lord, the party's name, my lord.
নিয়ে নিয়ে নাও।
But
Orderটা
this
সেটা সাইড করে
petition, the present petition has been preferred, challenging the order dated 9th August 2024, passed by the London Tribunal in an original application being weighed 1091 of 2023. By
এসছে নাকি? Item number
6, my lord.
Yes.
I am for the state led by Mr. Galib, my lord.
led by,
Mr. Galib, my lord.
where is Gali?
My lord, he is engaged in court number 1. He is on legs, my lord.
What, expeditious hearing?
No, my lord, I'll tell you, lordship, my lord. Against an interim order passed by the tribunal.
You have come up.
Yes, I have come up.
You are the, who are the
I was the respondent. I'll just briefly tell you, lordship, my lord. I am the owner of a land on the Eastern Metropolitan Bypass. Initially, my lord, this land, a larger portion of the land was taken over in acquisition for the purpose of construction of the Eastern Metropolitan Bypass. My lord, in 2012, a person claiming to be a Thika tenant filed a form and got a declaration that he's a Thika tenant on my land. So naturally, we went and challenged. So when that challenge was there, that matter came up before the LRTT, thereafter before the High Court, directions passed. Then Tribunal disposed of the application, OA application, by directing the Thika controller to consider, based on hearing the parties, consider and come to the conclusion whether the person who claims to be the Thika tenant is actually a Thika tenant or not. So that exercise was undertaken, and now the Thika controller has come to a conclusion that this is not a Thika land and the person is not a Thika tenant. But against that, he has come up in LRTT, the person who lost. In that proceeding, the LRTT has passed an interim order of status quo. While passing an interim order of status quo, it has come to the conclusion that the previous order of 2012, since it was not set aside by the LRTT while sending the matter back, the tenant, the Thika controller could not have passed an order, because that order, the subsequent order of 2024, which was under challenge, that order, according to the LRTT, is an order in review, and being a quasi-judicial authority, it doesn't have the power of review.
Who is the original applicant?
Well, now the interesting part is, now when we serve upon the original application, naturally we serve upon the address which is mentioned in this original application, all through from 2012, whatever address he is given, because if you are a Thika tenant, you are supposed to be residing in that property. Now, my lord, interestingly, the affidavit of service gives us an additional ground. Where is the affidavit of service? Yes. Kindly give the affidavit of service. It comes back with an endorsement. What is the endorsement? No such person. And I'll show you, lordship, only one page. Just only one page.
Then what is the status of the land now? You are not, you are the owner.
I am the owner. I am sitting by the fence and watching my land. He is let out. Well, that's another story. He has let out to the entire property. It's now become a 4-storied building. He's let out the entire property to a showroom. So there's a furniture mall over there. And he's getting.
Go and buy some furniture.
Yeah, that's all I am doing.
What is the problem? Yeah.
Watching people coming, going furniture from my land. He's getting.
Bring the furniture from there. You will also be happy. You will be happy.
The only difficulty is that somebody is selling furniture from my land. He's getting rent worth about 30 lakh of rupees from my land.
Don't be greedy, sir. Take the furniture, go.
Furniture, I will now, right now, I'm just happy with photographs, not even the furniture.
Then the original application contains that address.
Yes, I'm looking at the verification. The verification says residing at this address.
Tribunal held
Yes.
that remanding the matter back was wrong.
No.
At the time of remanding matter, the order was not set aside. It is implied. It should be set aside. It should be set aside.
Why should
Otherwise, why remanding?
And the person participates. It's a contested hearing. Your lordship, my lord, our limited scope of the present appeal is, my lord, that part of the order which is come to that conclusion, because at the interim stage he's already decided the appeal. So that should be set aside. We are not concerned with the status quo, only that part.
But what do you want? We want to accept this as good service. that there is no name, or you will yeah, try again to press service?
Because if your lordship will see, I have served in the address.
Suppose
Proper address,
set us,
proper name.
if we set aside that order,
My
the
lord.
status quo will go. Status
No,
quo
I am
order-
saying your lordship will set aside only that portion of the order by which the tribunal has come to this conclusion, because it decides the appeal at the interim stage.
Hmm. Now, what was his prayer that কি করে আসবে না? Any advocate appeared on their
Yes, we contact him, he's refused service. He has appeared before this court, that court, at all stages he's been appearing.
We record an order. আসুন, Mr.
Give the name.
Senior advocate appearing for the heard Mr. Bose, learned senior advocate appearing for the petitioner or petitioners,
Petitioner.
petitioner, comma, who is the private respondent in the original application,
Devanshu
the
Agarkar.
way such and such, preferred by one Uttam Kumar Das,
My lord.
being the respondent number 3 hearing. Mr. Bose informs us that the copies of the writ petition as well as the copy of the writ petition was sent by registered post to the respondent number 3, but it has come back with the postal remark,
No such person.
No such person.
quote unquote, no such person. আচ্ছা, ওটা রাখবে ওই
That verification in the OA application filed by him.
মহাভারত আবার রাখতে হবে তোমার, হ্যাঁ রেখে দেবে? You have affirmed an affidavit of service.
Yes, yes.
Where is that?
Affidavit of service has been given.
So keep that treasure with you. Let the affidavit of service, comma, as filed, comma, be kept on record.
আমি একটা রেকর্ড করে দিন না, ওই যে যেটা ফিরে এসছে ওটা ওনাকে কাস্টোডিয়াল আর কোর্টের অত জায়গা নেই, কাস্টোডিয়াল এজিস হবে।
You are for the state.
For the state.
My lord.
আচ্ছা। Records reveal that one, where is the order? Page
1016. 1016. This would be the last volume.
জোগাড়ও করেছে।
This is the order of 24th of December 2024.
Records reveal that one Mr. Mohammad Abdul Alim, comma, Mr.
ওই যে ওই
কি আসছে? ওটা ছাপিয়েছো বাবা? ছাপলিটা ছাপিয়ে দিয়েছো? হ্যাঁ? কে কে করছে?
বানানোর জন্য দিয়েছে।
ওটা তো কাকে দিয়েছো? Monday.
Monday.
And in the meantime, if you don't send the
with folded hands saying my in teeth of the injunction order passed by Lordship of single judge, possession has been taken over by keeping a seal. Kindly, I will not place anything. Kindly peruse the order impugned before my lord. If my lord file any flaw in the order, I will not make any submission.
ও তো পরিশ্রম করতে হবে তাকে। Who is your advocate on record?
I am advocate on record.
Instead of going today, you and the
No, my
other
lord,
one,
kindly hear me, hear us, then pass this.
we will reject and put the date that on that date.
Kindly hear it. I am out of business in order passed 2023 interim order passed continuing till 2025 till that day when the possession was taken, interim order was subsisting. I have concluded my submission before the single judge.
Mr. Basu,
Okay,
we have
take
to
possession on Tuesday.
No. Kindly hear it.
In this,
Kindly hear it.
within this 3
Kindly
days, what benefit you
from
will get?
20th, my lord, I am running business. I'm out of possession from 20th. It is in teeth of the court order. Order says
it is under lock and key, Mr. Basu.
lock and key of mine. They have put a seal. I cannot enter.
Right. That has been directed to be removed.
My lord,
That has been directed to be removed, and you should be given.
with possession, and I have been injuncted not to create third
not
party
to
interest.
create third. So we have to hear Mr.
Kindly
Basu.
hear it.
Just now mention tomorrow.
Kindly hear it. Otherwise, I will be in street. My entire business, my livelihood has been staked. My lord, kindly peruse the order. I will not make any submission.
Since when you are out of possession?
20th.
20th
20.
February.
On the following, yes, on following day, I mentioned this matter. The honorable judge was not there. It was assigned to another bench. Matter was hard.
Today is 27. So my lord is
27, 7 days. But
Heaven
order
will
was
not
passed
fall,
on
Mr.
the
Basu.
next day.
We do not want. We are requesting you. We are requesting you. Suddenly, we cannot avoid you. We will hear it on Monday. First matter.
Kindly hear it.
Monday.
My client will die. My client
Nobody
will
will
die.
die. Nobody will die.
I'm sorry, my lord. I request. My lord, kindly visualize my predicament.
I'll not do anything. I'll not change, alter.
This is my predicament.
I'll
I'm
not
running
intact.
business,
I'll
my
not intact
livelihood.
anybody. I
My
undertake.
livelihood.
Whatever is
Your
there, let it
lordships
be
are
there.
not violated in the impunity.
Well, totally wrong because he has got some other business place. One crore 50 lakhs
Well, I
is
am not-
due.
If you
1
lordship,
crore 50 lakhs is due. More than 4,000 square feet property. He's enjoying like anything.
Kindly-
Lease expired long back.
Yes, yes,
Kindly
everything-
petition Monday because just now I've been briefed. I am also not I'll come on Monday. I can assure you.
then no stay should be granted.
বাহ কি মজা অদ্ভুত ব্যাপার
নাচ খেলিও না।
আপনি তো হাসছেন যে
আমি হাসি।
এক্ষুনি হোক আর ওখানে অপোজ করছিলেন যে হওয়ার দরকার নেই
হ্যাঁ।
মানে এখন এক্ষুনি হোক নো আর্জেন্সি আগের বার বলছিল কোনো আর্জেন্সি আর্জেন্সি ক্রিয়েট
শুনে হারিয়ে তখন কিটা ভালো পেয়ে যাবে
সিক্সটা return his R6 so that he can use 3 R6
until further order differing such.
ডেটটা বলে কি এই ডেটটা ডিফার্ড হবে
Now,
শুনতে হবে তাহলে।
Let him deposit one question. Whether you are claiming that based on interim order, you are removed from possession,
Yes,
you are ousted
yes.
based on an interim order, whether that
No, 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 no. Violation of interim order.
violation of
Violation of interim order. Otherwise, my lord, my voice should not be so high.
No, that is always do, doesn't matter.
Always.
one code, you are not owner. That
I am the lessee.
Not owner,
Oh, both cannot say. Let the appellate
it is
proceed.
my grievance.
Right, আছে, continue.
1,50,000 due.
1 কোটি।
One course 50 lakhs. And my lord, will be surprised to note, lease expired 2018. Merely is enjoying. When we enhance the rate we claim, my lord, they challenge it.
Fail.
Fail.
It was dismissed.
I have committed a wrong. Even a murderer gets a chance. Let me hard on Monday, full pleasure. If I lose, I'll lose.
It dismissed হয়ে গেছে finally. যে হ্যাঁ,
Let the possession given
It
to
is
me.
not
If
maintainable,
we
it
lose,
is.
can you take the possession from me?
আর সেই অ্যাপিলে আজ পর্যন্ত কোনো অর্ডার হয়নি 2 বছর ধরে ওখানে আর্জেন্সি।
actually you are, if you entitled to get possession, you will get possession. But one litigant has come before the appellate forum, and being an appellate forum, we are bound to give some hearing to them, whether they have, their grievances is genuine or not.
Yes.
So now
Do that.
we are being forced to enter our, apply our mind to the entire.
Oh, I cannot force.
In a short span of
I
time.
cannot force.
Within
I
a,
cannot force.
oh no, within a short span of time. Because in such a hottest manner, the order has been passed. 26 order passed, effect has been given on 26 at 1
Yes.
PM.
But kindly,
30 PM. If anyone is aggrieved with by that order, he will not be get the forum to ventilate his grievances.
is it my lord pleasure?
Grateful to Lordship.
Just a short.
No, I will not make any submission. Kindly peruse the order. If my lord thinks anything is there, I
Again,
may
my
not
lord,
make any submission.
is my appeal.
প্লিজ মিস্টার
Place the order only, nothing else.
My lord, before that, kindly spare me. Before that, there is some mystery behind of it. I couldn't have understood, my lord, a person.
Accident
Heaven will not fall.
actually, I was.
He is talking about the business. He has got another place of business. And he is not doing nothing.
হোয়াট ইউ আর সেইং মিস্টার ব্যানার্জি
My lord, for the timing, I am saying, if you also wants to hear me at length, I'll do that, no problem. But at the same time, kindly consider, a person's enjoying more than 3,000 square feet.
প্লিজ প্লেস দি অর্ডার মিস্টার লেট আস আন্ডারস্ট্যান্ড what was the urgency in moving the
For this reason, my lord, today at 1:30 PM, court has died to open the lock and give them the possession.
please place us the
Yes,
order.
17.
Let us see when Mr.
Kindly come to 17, my lord.
Yes, 70.
Kindly don't misunderstand me. This is a situation my client's
Yes,
livelihood at stake.
No, no,
Yes,
why
70.
should we
Again, my lord, talking livelihood.
we
This
have
is, I
nothing
should
but-
say, this is unfortunate. He has got
Livelihood
another
right
place of
কোথায়?
business. This is, they're doing nothing over there.
আচ্ছা মিস্টার ব্যানার্জি প্লেস
Yes, yes. Kindly come to my lord, the relevant part of this order to save your lord's valuable time.
No, no, my lord. I request your lordship to read the order.
I'll read.
I
I'm not
request my
afraid.
lord to
Yes,
read the order.
because the
Not in
day
this
on
way.
which, the day on which matter is open, very same day, the such order is passed.
Disposed.
Disposed of.
কপি দিয়েছে পরশু কালকেই ডিসপোজড
How is it?
একদিনে।
where is the order of 20th February 2025
Hello, that is also very confusing. I'm coming. Bar karo.
you will
Yes.
argue please show us that which is the
Yes,
page
28 February, Kolkata bar karo. He is forcing the court to hear the matter right now, in spite of the court says.
Please
Court
don't
says-
use
No, he
force.
has-
I cannot
he has
use the
got
court.
words.
I have not.
What
so
more?
much
on the contrary
Oh,
your
we
junior
are-
has put
I have no
Kindly
force, no
appreciate my-
strength.
Kindly appreciate my
forcing the court.
anxiety. If you lordship, it is not hard. or-
172.
which is the page
172.
Please, sir.
I will assist.
Did
So
you
you have read.
No, no, this.
So how you are saying that?
No. These orders, it is in my knowledge. That's why. Just now it is handed over. 5 minutes back.
you are Deepak Kejriwal
ওই
I am the
ঘরটা, ওই
father
ঘরটা বার
petitioner.
করুন আছে, এইটাই। কোনটি যেছে জানছি, 28. 28. My lord is asking for to show the 28.
no that 20th February order
20th February.
we have got it page 172
172.
172 হচ্ছে ওই পজিশন 172 যেরকমটা পজিশন নেওয়া হয়েছে এটাকে ওরা ক্যান্সেলেশন চেয়েছিল অ্যাপ্লিকেশনটাতে ওদের ক্যানটা বের করো
172, yes.
কোনো
Hey, we
প্রেয়ারই নেই
cannot
ফর
read this
ক্যান্সেলেশন
page also. পড়তে পারছো?
Already that was done, everything.
Right, there's no problem.
And copy added by them.
ওদের ক্যানটা দাও হ্যাঁ ওদের ক্যানের রিলিফটা দেখো এটাকে চ্যালেঞ্জই করেন বলেছে পজিশন দিয়ে ক্যান 7 এর প্রেয়ার বের করো
So many things to be argued, so many things to be placed. Yesterday it was hard and yesterday it is past.
Tell us, Mr. Banerjee, what was the story behind?
Story, yes. Most unfortunate thing is this, admittedly, some admitted fact is there. Admittedly, Mr. Bose client was a lazy. He was a lazy.
Yes.
He was a lazy.
And
And
lessor was the industries. West
yes, we are for the lessers.
You are for West Bengal small industries.
West Bengal Small Industries Development Corporations.
Oh, you are the lessor.
Yes,
You gave it to Mr. Basu's client by a lease deed.
this did.
Then what happened?
15 years. 15 years.
15 years.
After expiry of the lease,
When did it expire?
সেপ্টেম্বর 2018
September 2018.
September 2018 it expired. Yes, then
Then
they
and
did not vacate.
not only that.
Acha, then what happened? They did not vacate. What
Yes,
did you do?
Then my lord is actually happened.
You have
I gave
passed
him
an
an
order
opportunity.
after 7 years.
No,
ওরা রিড ফাইল
I came in, I gave an opportunity. That we just do one thing, our rent is enhanced to the tune of such and such amount. So if you pay that, we'll reconsider your case. He challenged it and he fell.
What is the rent?
72
per
per square feet. Everyone has agreed.
How much square feet? 2000 something.
4000
4,000 square feet.
7 square feet less 4000 square feet
Acha, wait, then
And he, my lord,
everyone agreed means there were other persons also.
other person, my lord, other tenants,
occupants of the
other occupants, other lessees, other lessees,
Everyone is to speak.
other lessees.
হ্যাঁ
একটু দাঁড়াও ভাই।
No, we are not
একটা
concerned
clear-
with
No,
other
no,
places.
question is
We are
yes.
concerned with
Question
you.
is,
How much land was given to you?
That is written
Hey,
there.
sir, how
4000
much?
3900
initially
7
4,000
square feet less 4000 square feet
All right, then what happened?
Then, my lord, he challenged, he failed. Appeal was paper, no action was taken. Appeal was pending, no stay, nothing. And in that, at the time of disposal of the trial court, just casual observation is made. At best, is a holding over, at best. But question cannot arise. Entire concept of under section totally change. Initially, even 1 month rent is enough after extra the lease. Now, Supreme Court is very candid, said no, even series of rent is paid, it doesn't matter, holding over is also illegal. It cannot be holding over. Anyway, now when he served the notice, that was challenge. That was challenge. By enough is enough, now please oblige us by vacating that. You are not paying finance rent, you are enjoying that and not even paying rent. Now due is 1 crore 50 lakhs.
All right.
আগে রিটটা ডিসমিস হয়েছে পেজ 80 তে
And page 80, kindly see my
আগে রিট পিটিশন ফাইনালি ডিসপোজ
earlier it is on file is on page 80.
পেজ 80 যেটা ফাইনালি ডিসপোজ লাস্ট 2 ইয়ার অ্যাপিল পেন্ডিং নো অর্ডার হ্যাজ
Acha,
বিন পাসড
you page 80, that writ petition was preferred by them.
Them
Challenging what?
72 square feet দেবো না টাকা yes
enhancement.
Enhancement of rent.
That's
Page 80.
80. It's a very lengthy judgment, everything is considered, they challenge this.
Judges.
I'm sorry.
So that was turned down.
Turn down. The
Next,
prayer which was made there,
then
kindly see my lord.
no appeal was preferred against.
Paper, not only that, keeping that appeal pending for a month.
ওদিকে যান, ওদিকে যান।
Yes,
বলছি
my lord,
ওদিকে যান।
no action was taken. To move the appeal, stay, nothing. It's pending. So my position was precarious.
So during pendency of the appeal, you issued this notice of February 25.
Naturally, my lord, because yes,
We are not
Yes.
asking any explanation.
I
We
see.
are wanting to know.
yes,
So the appeal is still pending.
still pending, no action is taken.
লাস্ট 2 ইয়ার পেন্ডিং
Totally wrong fact has
Any
been placed.
interim order was passed. in the
Nothing.
এখনো
All right.
For the last 2 years, it is pending, no attempt was made. Just by showing this appeal is appeal, that's all. I don't mind. Any order can be passed. Right now, they may be directed to deposit 1 crore 50 lakhs. Right now.
মানে কোনো আজ পর্যন্ত hearing
Let them deposit.
কোর্টের কাছে থাকুক। I
A
will not take-
person is challenging my action, he must come with a clean hand and with a clean mind. His whole intent.
ছুড়ে ফেলার জন্য।
ক্লিয়ার হয়ে যাবে
অর্ডারটা 3 বছর ধরে পড়ে রয়েছে। 23 সালে তো রিট পিটিশন আগস্ট 2008।
ঠিক আছে পেয়ে গেছি।
Most, I'm sorry,
Very good. Now what did the
most
single judge say?
interesting, my
No,
lord.
what? Now this was the factual. Thereafter,
But
this
no, no,
notice
but
was issued.
something else.
My lord, we have not reached to the read court. This is not the fact.
Arey, we will hear you, Mr. Vasu. Take your seat.
That excitement shows something wrong with him.
Now, after this notice was issued, they challenged before the writ court.
Still pending.
Now, no, this writ petition.
Oh, this petition, disposal.
This writ petition from which we are hearing the appeal. The
It's an
subject
application.
matter of challenge in that writ petition is the February 25 order of yours.
No.
The part,
Well, I'm really confused, my lord. I'm confused. He's also a senior advocate. He must know how to address the
that is
court.
why so strong.
That's why
Yes,
I'm trying
that's
to
what-
assist the court, not to mislead.
If it is a form of assistance, court certainly
Then
leaves
what
the chair.
happened? Then what happened?
Now, my lord,
What was the reasoning given by the learned single judge?
kindly appreciate one aspect. Kindly bear me for a moment. What was the application which was moved? They file an application in connection with the main read. Court may be directed that, well, log may be open. Nothing more, nothing less. And rest of the
39 is
position.
the prayer.
But 139 is the pair. Kindly see the pair.
Page one-
It is not the hearing of the main read application.
It's only can. Page
Sir,
one-
if you continue this fashion, we will release it on our personal ground. It is very disturbing.
That is always doing. That is always doing. Nonsense. Oh, don't be over smart. I may lose, I may win. If you behave like this, I'll leave this. তাহলে তুমি নিজে করো। I'm sorry, my lord. You are bringing unconditional apology.
Petition was filed challenging one show cause notice dated August 23, 2026. Order September
Aste,
14,
aste bolo.
2020.
Aste.
My lord is reading, my lord. No, but what is actually, my lord, Chokuda asked me, what is actually the case?
Now, when did you take over possession?
Did take over?
Page one-
And when did you put
One,
the
can you see the
padlock?
page 139? 139.
Yes, this is the challenge in the writ petition,
No, no, no.
20th February 25.
Is there a can application in connection with the read?
Who filed? You filed.
Read petition.
Read petitioner.
Acha, then
I could have understood the main matter is being heard and disposed of. A can application was filed, and in order to dispose of this can application, with all respect to the court below, I am also human being, I can commit a mistake. The court has decided everything, keeping nothing. Case is gone. And without any condition,
No, we are asking when did you put the padlock?
padlock
22-25
20th February
20,
2025,
Page 139
page 139.
যেটা প্রেয়ারে ওরা চেয়েছে।
আস্তে কথা বলো। 139. Kindly
So
travel to page
when you issued that notice, was there any order passed by the court subsisting?
My lord, that is a controversy, that is a point to be taken up at the time of final hearing of the writ. Because if it is so, kindly see, if it is so, naturally, there is no alternative. Question
Their
is,
allegation is that violating the interim order, you have take possession.
no, did they file any contempt application? No, but did they file any, cleverly they have avoided filing contempt applications for obvious reasons. But there is a confusion in the order itself. So that, to avoid, because confusion, unless, if there is confusion, court certainly entertain the contempt.
Mr. Banerjee, we are wanting to know from you, before you pass this order of 20th February, was there any subsisting order of court?
But so far we are concerned, my lord, as I am told by them that, well, as such, there is no interim order.
What is the as such interim order which was produced? Can you show us that page?
Yes, why not? They said there is a little bit confusion, so I'm coming. extended
14th of January 2025.
151 টা first order.
Page 151 is the first order. Time frame that was extended. 151.
সব ছাড়ো, তোমাকে তো আজকে প্রোটেকশনটা দিয়ে অন্যদিন।
Have you got it, my lord? 151.
153.
151 is a continuation. 151 is the first order, which my lord wanted to know.
That was in a separate writ petition.
That is a different petition. The original writ petition, which was disposed of by Justice Bhattacharya, is regarding arrangement of the rain.
Right? Now,
Is another writ petition.
this
It is another writ petition.
এটা কত?
নাম্বারটা 2504
25046.
out of 500
25046. Yes. In you are showing us page 151.
Yes.
151 is an order passed in the same writ petition. This
That is,
pending.
yes, same writ petitions.
আচ্ছা বল।
My lord, kindly take double.
Yeah.
I'm sorry. We filed an application for vacating. Nothing has been done. Days in, days out, adjournment and extension.
Application means there was an interim order.
Kindly, I'll come to that. I'll come to that, my lord. On the joint pair of the parties, the vacating application such and such shall be taken up along with the writ petition in view of the urgency shown by the respondent in the writ petition who applied for vacating the interim order on the plea that due to the existence of interim order, the respondent state authorities are suffering immensely. The next, again, it was extended. Kindly come to next 153. Hearing started, hearing going on. Then 155.
Then ultimately, when was it heard?
Ultimately, it is not even fully hard.
Vacating application was not disposed of.
And not only that, it was not fully hard. Time again, there took time.
What was that interim order, Mr.
Interim order that
Interim order, what is the?
first interim order which was passed. If I am not wrong, subject of corrections. 147.
Page
147.
147.
It starts from 146. The director to file appeal in opposition 2 weeks after vacations. Petition is at liberty to file appeal reply. In the meantime, position of the petitioner shall not be disturbed till 15 December 2023. So time to time, it was extended. That created sometimes some confusions.
Possession of the petition should not be.
Possession shall not be disturbed.
Now, this is up to 15th December. Now, kindly see. Next page, 48. 31st July or until further or whichever is earlier. Again, 138.
Extended.
Kindly see the interim order granted earlier is extended till 31st July 2024 or until further whichever is earlier. Then next, 149. Again, it is extended. My vacating application is pending, again extended. Again, 149. The interim order passed with writ petition was extended from time to time. The last of such extension was passed on such and such date, 24. Mr. Priyaputo Bhattapal and the state response. Mr. Devaputo Banerjee, Learned Council, having with the opposite hears such prayer for extension on the ground that his client vacating application is still pending and the interim order was obtained in a manner by petitioner which is not tenable in law. Be that as it may, the interim order lastly extended May 17, 2024, stand further extended till August 31, 2024.
Page 171, it was extended until further order.
I'm coming, my lord. Then next, 152. Page, my lord is referring page 170, 171 or 170.
Interim order will be till January 31st.
January 31st. Kindly, there is some confusion here. Kindly see. This 171 page is always creating confusion. There may be mistake on the part of the client that to understand the order. Kindly see. For the end of justice.
During subsistence of this order, you issued the notice.
Yes.
20th of February.
Yes. Kindly see, my lord. For the end of justice, the writ petition shall appear under the hearing for us on February 19, 2025.
এনজয় করেছে ও এনজয় করেছে রিটার্নিং ম্যাজিস্ট্রেট দিয়েছে
14 January, the order that
they are running any business there.
nothing. I can ask.
It
It is some articles are lying over there. And they are actually doing business. Asansol or Purulia. And 1 crore 50 lakhs is due. One after another litigations. Every time they're creating a problem. And 14 January.
Mr. Banerjee, you have taken over possession on the date of operation of the interim order.
Kindly appreciate one aspect. On 14 January 2000.
That is why the honorable court was so annoyed.
Kindly see the comp 170, page 170. 170, once again. Which is the date of the order, 14 January. Correct? Then
But
kindly
a
next
judicial
page.
process has to be followed, na?
No, kindly go to the next page. Malad, if there is little bit confusion, naturally court cannot take say.
There is no confusion.
Kindly come to page 171.
Yes.
For the end of justice, the writ, have you also got it, my lord? The writ petition shall appear under the hearing for orders on February 19, 2025. Parties jointly submit that the interim order existence till January 31st. In view of the above, the interim order stand further extended until further order. But this until further order.
এটাই তো গন্ডগোল হচ্ছে
না গন্ডগোল হবে না
Even if whatever may be tenants holding over or statutory tenant, according to you, what would be the character? But you cannot take forceful possession.
Well, had it been a case that, well, there is a really forceful possession is something else.
Particularly when interim order is subsisting.
No, they are in possessions and there is a resistance. They are not doing business.
So forget about everything, Mr. Banerjee. Court must have some sanctity, na? I pass an interim order today.
No, I always appreciate.
Authority says that do whatever you want.
No, authority can't say. Authority can't say.
Can't say. So, but they have
But there is
done.
some, but there is a little bit confusion. Maybe.
Pardon.
Maybe by the instruction of the lawyer, because client is not to know. Maybe.
Then hand over the possession. They will keep it.
One thing, my lord. One thing. What about the rent? In one case,
considered.
I'm coming.
Record.
I'm coming, my lord. In Roxy Cinema, my lord, corporation put the padlock. I appeared for the corporation at that time. Before Justice Dipankar Datta. Mr. Kolan Bandhavada appeared, shouted like anything. He immediately should vacate it. I'll vacate it, provided you deposit the money to the tune of. They are also same fact to the tune of 5 crores. First you deposit, then you take the position. Here, my lord, every time. Very well, I don't mind. Let them deposit 1 crore 50 lakhs. Conditions. That is due. They lost the case in the trial court. The paper appeal 2 years they waited. They didn't ask for any stay order from the appeal court. So they must pay for that. Government authority cannot suffer in this way. 1 crore 50 lakhs is due. So let them deposit the money. Very well. I don't mind.
এটা পরের দিন বলবো পালিয়ে যাচ্ছে স্টে না করে ম্যাটারটা তো আবার শুনানির জন্য রাখবে এবং টাকা দিতে বলা হবে অলরাইট মিস্টার ব্যানার্জি ইয়েস
They will not pay, they will enjoy, and one after litigations, and this is the way.
So Mr. Banerjee, why didn't you raise this issue before the writ court? You could have said that yes, we have taken supervision. The compelling reason was this. Ask them to secure this amount and.
My lord, what initially? I'm sorry.
No, Mr. Banerjee, you could, instead of putting that lock and key, they should have asked you that go and mention before the. You have fought the matter for so long. Court got annoyed due to this reason. That is at your risk and cost.
My lord, one thing,
When a subsisting interim, today suppose I pass an interim order.
no, I appreciate, my lord. I cannot support, but it is not my
It is
instruction.
only for that reason this order has been.
No, one thing is very clear. There may be a misunderstanding.
No, what do we do is, we will keep the matter returnable. As you are asking, this payment has to be made.
Yes.
You come to us with the documents. If they do not pay, we will take appropriate steps.
Now, my lord,
Finally decide.
We shall finally decide you give person.
my lord,
We will finally decide.
You give person.
now this much I can tell you, lordship, my lord.
Now, Mr. Vasu, what about
Even if
this
a
rate?
lawyer instruct like this, it is not proper on his part. As it is formal losses, my lord, if there is really a court's order, it should not be done. But probably it is in his mind, is confused because he is not so mature. I would have said, no, first you ascertain the position.
No, we understand that you people were frustrated. Because why? First writ petition dismissed, appeal kept pending for month. Person
Yes.
goes on enjoy. We understand that.
Yes.
That you are frustrated. That how long we will suffer. You could have come to
And
the
kindly
court and
see
said,
one after adjournment, not to adjournment.
Mr. Banerjee, you
I started my argument. Today, on behalf of the petitioner says, এটা ঠিক কাজ করছে না।
Kindly see the orders.
1 lakh
Banerjee is saying
50,
something
1
which is not on
crore
orders.
50 lakhs.
1 crore 50 lakhs.
Have you calculated since when these
It is calculated based on your enhanced.
Obviously, my lord.
No, as per the old rate, how much you get?
Old late, my lord, I do not know what.
I am still dead paying.
They old late. Well, they failed. They failed because they couldn't justify their conduct or law before the single bench.
During succession of the interim order, they took possession without harassment. সেটা পরে আমরা
Lord, may I get 3 minutes time only?
Kartik.
I get
2
3
PM.
3 minutes time before your lordship dies. I'll show to his lordship only 2 orders.
Well, my lord.
What is the genesis of this writ petition?
Don't get annoyed. Mr. Banerjee, you're
Annoyed?
so experienced.
And annoyed কেন হবো? Annoyed প্রশ্ন। আরে
This has
যেটা
been-
বলছি শুনুন না। আপনার সুগার আছে না? নেই, বেঁচে গেছে।
Oh, now, my lord, there is a notice to show cause for eviction. I replied to that notice of eviction. Order has been passed for eviction. Kindly please peruse the order of eviction. My lord has never seen that. Page 113. এলাম দেখলাম জয় করলাম হার্ড কনসিডার রিজেক্টেড kindly come to 113
This order is under
under challenge in the writ petition, the present writ petition wherefrom this my lord is hearing in an interlocutory application.
First order was 14 September 23. This is what you challenged.
No, this order is challenged 14 September 2023.
What is this order placed?
See,
Started.
Amit Kejriwal such and such executive director, the second hearing dated such and such that they have remained factoring within Purulia and the present stall at first floor subject matter Shilpa Bhavan has only been used for warehouse. No employees are working.
So this
But
order
consider rejected
this order was passed in which proceeding?
in a 1976 proceeding. They
It was under which act?
1976 Act, eviction of
Authorized document.
in that
So this prescribed authority is
pass this order.
like the estate manager.
Yes,
Oh.
this is the order. Subject matter of challenge. No reason, nothing. Division bench shall you plead holding over as placed. I am not troubling lordship on that. This is the order subject matter of challenge in the writ petition filed on the very first day interim order was granted. Interim was continuing. They filed an application for vacating interim order. Hearing both commenced. I concluded my submission for the petitioner. And everywhere, my lord, will find one day I was in virtual mode. Court recorded that Mr. Basu Jr. asked for adjournment, but Mr. Banerjee continues his submission. So there was no adjournment over our instance. It was continuing. Court was available. So, my lord, this order was passed on that extending interim order until further order. That was challenged. That has not been placed before, my lord. Kindly come to that order. 123. This order, which is until further order, kindly, I request your lordship, 3 pages orders, kindly peruse this. What is the Had my lord kindly got it? 123.
Dismiss, appeal dismiss.
Not only that, my lord, kindly read it. The matter has been mentioned such and such. The appeal is arising out of order. The grievance of the appellant is that the interim order extended mechanically is not quite borne out from the order dated such and such. Moreover, it appears that the parties have submitted that the interim order was in existence till 31st January and was extended from time to time. The extension of interim order from time to time has not been challenged. It is unacceptable that the said interim order was extended mechanically as the initial order was passed on merits and on contest. And it is important to perceive the rights of the parties during the pendence of the proceeding.
This order was, where is the writ court order?
That is, my lord, the interim order until further order. That is, my lord,
Page
page 172 or 74. Just a minute, my lord.
174.
Just now it has been placed. 174. Now, kindly come to 170. In view of the interim order, দুবার হয়ে গেছে.
171.
171.
So against this order,
Appeal has been prepared. Kindly see the comments of the division bench, honorable division bench.
অত আওয়াজ হচ্ছে, দেখছি তো। উত্তেজিত করেছে।
ফিরে এসছি, আর দরকার নেই, হয়ে গেছে।
Yes.
Well, kindly once look, read that order of the honorable division bench.
On the previous plea that the interim order expired on 19th February 2000.
That is their case. Stand down. Now same contention has been now been repeated. And liberty granted to approach the honorable single judge.
Interim order expired. Wait till resume office. Mr.
Court unable to swallow, the division bench unable to swallow the contention of the
Now, how much you are depositing rent?
70,000 per month.
Yes.
My lord, why I have shown to lordship the order of vacation? I am not on the ground of default. My eviction is not on the ground of default.
You are wanting to know
Expiry of lease, and I have a right to be plead holding over. That is to be decided by the authority. So far as the contextual rent, I am paying till today.
how much is that
70,000
per
month.
70.
76,000 per month.
6,000.
Oh, that's a ball now. Oh, sorry, my lord, 56,000 per month.
56,000
per month.
and they are accepting.
Acceptance is there. Enhanced rate acceptance or holding over is a pointer.
Holding over.
If it only mechanical, my lord, no enhancement, I could not plead holding over. The division bench recorded that. So I have to plead holding over. Not I have shown to lordship the order impugned.
Party learned advocates appearing for the respective parties and considered the materials on record. Prima facie, it appears that the
position and matter sent to courtroom number 2. Therefore, something should have been left to be decided for affidavit. Once entire relief is granted, thereafter
আচ্ছা, শোনো,
direction what I will.
ওই অর্ডারটা ওই
There lies the difficulty.
Let this order be treated as an interlocutory order.
Grateful
We
to
shall
Lord, sir.
apply our mind on it.
But grateful to Lord, sir.
কোনো লাস্ট লাইনটা কি লিখলে? However, দরকার লরি list the matter for further list the matter for further consideration in the daily supplementary list of this court on সোমবার কবে কম আছে একদিন
মঙ্গল
তারিখ দিয়ে
একদম
না না এমনি এমনি লিস্টে থাকবে আমরা শুধু ফার্দার কনসিডারেশন অন 11th March হ্যাঁ
অনেকগুলো হয়ে গেল
So then we keep it also next week রেখে দিই on keep it on কি আমাদের মান্থার সাথে বেঞ্চ করে তো list the matter for further consideration on 5th March.
Only one thing, may I pray, my lord?
5th March.
The special officer are directed to go on 1:30. Now it is 1:30. Can we extend the time? Let them go on 2:30.
My lord,
Let us see, we have not interfered with the order.
So
If the special officers are
no, then there will
special officers are not allowed,
then
then-
I know. And can you let me plead sorry, my lord, formally, because keeping waiting for 1:30.
কত চিন্তা
I said formally.
my lord, something, some nature of rest, inventory, I have no difficulty.
wanted to dispose of the matter.
This authority in subsistence of an interim order to take force.
My lord, there was no subsistence.
But-
With great respect, my lord, let that be thrust on any other day, my lord. On any other day.
I expected that due to paucity of time, I will not be able to give dictation in open court. And hence, I have dictated the review application, but according to my limited knowledge, it has been dismissed. And now let us take up the contempt.
Then keep some breathing space for the
No,
purpose.
giving place, I cannot allow the order to stop its effect. One lawful order, even for a moment, shall not be allowed to be stayed. Illegal. Lawful order,
Even if,
always
by higher forum.
I'll take its effect,
No, it will take its.
unless it is stayed by a higher.
No, that's why, my lord, that's why I am submitting my since.
So I am going to issue rule.
Yes,
I am prima facie satisfied regarding the violation. A contempt application to be. Now it is up to you. Okay. And review petition, it has been specifically held that issue was decided, raised and decided by this court, in which para it has been mentioned, paragraph 9, paragraph 15, paragraph 16, paragraph 17. It has been specifically stated. Okay.
Or other sufficient reason has also been considered, I believe.
Yes, that issue. So, under the guise of a review petition, we review, one court cannot be invited to reconsider the same. Okay.
It's entirely up to my lord.
This is an application. This instant contempt petition has been punished in contempt.
Yes,
Okay.
provided the
Okay.
order of the
Final committee report.
no. Yes, provided the order of the court has been brought to his notice.
Well, the director of personnel, the post
Because-
of the director of personnel. Now the new
Question
increment
is not
comes.
that. Question is not that.
Yes.
Question is what sort of responsibility this gentleman was.
Okay, on the next date. Okay, I am giving a short date. Sutana order to carry the.
My lord, let it, I am not sub.
Incumbent has
Let it be changed. The formalities should be maintained.
Post which the alleged contender was holding. ঠিক আছে, stop. In view thereof, liberty is given to the advocate on record of the petitioner to incorporate the present incumbent in this petition. ঠিক আছে, by way of amending the cost title of this present petition.
In court
আচ্ছা,
itself. In court itself, it can be done.
In court today.
There is no difficulty to that effect. What I'm submitting the little bit of knowledge I had, because this knowledge I have derived from
Mere
late
technicality.
No, not mere technicality. This knowledge I have derived from late Mr. Somaraditya Pal.
All the applicants, DBC, representative of DBC is present before me.
No,
A court can
I am
take
here.
judicial notice.
I am here.
And it would be that
No.
even
No,
the new incumbent will be represented by you.
no doubt. It's
Okay.
not that. Your lordship, for the purpose of contempt,
Let a copy of this petition along with this annexure be served upon the new incumbent. Is this better?
for the purpose holding him responsible that he has violated the order, he has to.
My lord,
Will you accept the copy?
Yes. No, I do not on that, my lord. What I am submitting is my all endeavor. Kindly don't take me amiss. That the person should be made aware that this order was there in his present post. He is duty bound to comply with that.
Okay,
Whether my
client
client,
time to take.
yes, what my client will do must be different thing altogether.
Mr. Banerjee has take responsibility.
No, not responsible, has
no,
entered
sorry,
appearance.
has stated that if the copy, you take service on behalf
Yes,
of
yes, yes, I shall.
has agreed to accept the service of copy of this contempt application, ঠিক আছে, on behalf of the new incumbent.
Yes, yes.
ঠিক আছে?
My lord, one
Acceptance of Mr. Banerjee shall be deemed to be an acceptance of service by
Upon the
the
present incumbent.
ঠিক আছে? আচ্ছা, list this matter for further consideration and next week করে দিন এসে।
Next week কবে?
এই, 5 তারিখে? ও, তাহলে on 5th? On 5th at same time?
my lord, rule can be issued 1, 3, and 4.
On 5th?
My lord, rule can be issued on 1, 3, and 4. They are same persons.
On that date, it is for Mr. Banerjee.
Well, since 1999, I am suffering. That's why that.
Okay, on that day. On
Well,
that
it's a
day.
legal battle, my lord. It's a legal battle altogether. It's a legal battle altogether.
Hey, correction for.
হ্যাঁ ওই ব্রিফটা দিক শুধু তো নামটা ঢুকবে এসেন দত্ত
এসেন দত্ত।
শুধু নামটা
কেন?
আর কপি তো বলবেন
বলো তো এটা।
হ্যাঁ এইরকম করে
But I appear for the KMD author for it. I am appearing for the petitioners.
My lord, we are the applicant for added respondents, my lord. We have filed our applications for adding us. We have not yet been added.
I have also made one similar application for addition of one, for adding ourselves party.
Who are you people?
My lord, in my case, my lord, what happened, my lord? My lord Justice Amrita Sinha, my lord, was pleased to dismiss our writ petition, saying that no, this merger we cannot claim the equal benefits. That was the position. Another set of incumbents, they moved another writ petition, which was heard by my lord Justice Bharadwaj, Rajashree Bharadwaj. And his lordship was pleased to view, his lordship was not agreeing with my lord Justice Sinha. So in this backdrop, my lord, this matter has been referred before this honorable bench. So if the reference is not from our case, the reference is from the writ petition, which was in which the order was passed by my lord Justice Rajashree Bharadwaj. But it is connected with our matter, my lord. If that writ petition is allowed or rejected, it will have a bearing on us, on our writ petition. Dismissed. It will have a bearing on this incumbents.
My case is also similar.
Whether there is any scope.
So you also filed, you want writ petition?
No, I have
Or same writ
My
petition?
lord, I was proposed respondent before the Honorable Justice Amrita Sinha, but without making ourselves party respondent before Honorable Justice Amrita Sinha, writ petition was moved, my lord. So, my lord, our interest is there, my lord. For this reason, my lord, we have made one addition of party application on behalf of our
That
clients.
was the first time.
We are the employee of that organization.
Here in that writ petition against that order, neither the petitioner preferred an appeal, not the proposed, the
Are
intended
you
parties.
opposing the addition, sir? Tell us. Are you opposing the addition? You are opposing.
May submit. One Mr. Deepak Bandokota, Dr. Deepak Bandha, being an employee of KMD engineer, filed a writ application which was heard by Honorable Justice Amrita Sinha. Prayer was for the promotion following the inbuilt principle of Kolkata Metropolitan Development Authority. This problem happened after merger of Kolkata Metropolitan Soils Development Authority, Kolkata Improvement Trust with Kolkata Metropolitan Development Authority by Gazette Notification in the year 2017. Question arose whether after merger.
We are not on the merit. We are
Hello.
wanting to know
No,
that these persons.
they are made they've lost in the matter, and Justice Sinha has specifically stated, so no, formation of any gradation list is not possible. And that application was dismissed. Which management side. And that judgment has been relied upon by management.
So the order affects both of them.
Yes, I'm grateful.
Order which was passed is where? Where is that order?
That has been annexed in their affidavit in opposition.
Opposition?
Opposition
The
filed by-
paper book has been filed?
আমাদের
Oh,
অ্যাপ্লিকেশনের অর্ডারটা
Yes. No. I think my my
Just
Order-
let us understand. We are
অ্যাডিশন অফ পার্টির অ্যাপ্লিকেশন
আমাদের কাছে কেন অ্যাসাইন হয়েছে?
My lord, may I point out the portion? My lord, may I, আমাদের can application? One of two party application. My lord, may I point out the portion of the order?
Wait. We call upon
No,
after we.
my lord, sorry, I'm extremely sorry.
জাজমেন্টটা কোথায় বই গেছে? Memo of appeal-টা কোথায়? কার্তিক একটু দেবে। দেখি এটা।
In my affidavit in opposition, that order is annexed.
ছেড়ে দিয়ে
What does it? What does it? না ওটা থাকবে কোথায়? ওটা তো কোনো সাবডিউ হয়নি।
So, who are the persons who approached Justice Sinha?
My lord, we,
Which one was the first application?
can one, my lord, the applicants in the can one,
Applicants in Can 1
can one,
approached Justice Sinha.
Justice Sinha.
And you?
Doctor, we were proposed respondent before the Honorable Justice Amrita Sinha, but without making ourselves party, my lord, order was passed by the Honorable Justice.
Who are you?
Lord, we are the employee of that institution, my lord.
How many employees?
My lord,
You are
we
in
my
Can
lord.
2.
My lord, we are in number, my lord.
Now, Dipankar Das Gupta case was filed before Justice Bharadwaj.
We are Vishwajit Mukherjee and others.
Which judgment is prior in time?
Justice Sinha's. Justice Sinha's.
আচ্ছা।
14 জন মানে 25 জন।
We are 25.
25.
You are 25 people. You want to be added as respondents in Justice Sinha's writ petition
Yes, my lord.
and not in Justice Bharadwaj's writ petition.
The present writ petition, my lord.
Present writ petition. এখানকার writ petition.
Oh,
এখানকার writ মানে ইয়ের
আমাদের ওই অ্যাসাইনমেন্ট একটা কি যে অর্ডার আমরা আগে অর্ডার পাস করেছি।
নজর তো আমরা নজর আপনি পয়েন্ট নিয়েছেন মিশে বসছে আমি হেরে গিয়ে তারপরে সেটা জয়েন করবো।
আমি অথরিটি একটা জিনিস ভাবছি যে তোমার ক্ষতি কি
You previously preferred a writ petition
My lord.
in which Justice Sinha was, where you have stated that in your application.
My lord.
You are
Vishwajit Mukherjee and others.
Where have you stated that?
My lord.
11/9/2003. Justice Sinha's order was 11th September 2023.
My lord.
আমরা petitioner,
Oh,
respondent.
So you people are the engaged by Kolkata Metropolitan Water and Sanitation Authority.
My lord, may I point out the portion of the order under reference, my lord? On the premise on which this was referred.
No, no,
My
we
lord,
are
kindly
trying
cease
to
our-
understand. Wait.
My lord.
You preferred the writ petition challenging. You are the employees of Kolkata Metropolitan Water and
Water,
Sanitation.
Sanitation, my lord.
You filed the writ petition claiming what?
My lord, claiming that a common gradation list should be prepared.
Just.
That was our moot contention, my lord.
Where is that here?
আমাদের রিট পিটিশনটা আমাদের রিট পিটিশনটা দর্শক দেখতে এসে আমাদের রিট পিটিশনটা কোথায় রিট পিটিশন এই তো
So,
এই বিষয়িত মুখার্জি মাই লর্ড we have annexed our রিট পিটিশন my lord.
so your prayer was for preparation of a common gradation
lord.
list on the basis following result of compare not to proceed with the promotion of engineers under the. That's it.
My lord, our prayer portion is 192 of the CAN application that we have filed, my lord. It is a part of
Now,
the writ petition.
what happened to the, this was allowed,
No, this was dismissed.
dismissed.
My lord.
After dismissal, when was it dismissed? 30th of July 2017.
Right.
Very good. Now,
Another set of employees
belonging to,
similarly placed with us. They filed another writ petition, which was heard by my Lord Justice Bharadwaj.
After dismissal.
After our
that
dismissal.
is Dipankar Dasgupta,
Dipankar Das.
for whom he is, you are a.
My
Now, his lordship differed with Justice Sinha
Right.
and referred it to
Right.
us. Very good. You are similarly situated.
similarly situated with them.
You are similarly situated with Mr. Sarkar.
Mr. Yes.
Huh?
Yes.
And who are you?
My lord, we were the proposed private respondent before the Honorable Justice Amrita Sinha. We are the staffs of KMDA, not from KMWSA. We are supporting the KMDA.
No, right, but the KMDA was a party respondent in that.
Yes, my lord.
So you are the employees of KMDA.
Yes, my lord.
You are the, what was your
You have the benefited of this action under challenge.
Yes, my lord. Yes.
You are the beneficiary.
Yes, ma'am. Yes, ma'am. Yes.
They will give benefit ultimately if they succeed.
কোনো beneficiary going to dismiss.
Huh?
Amrita Sinha ওদের ফেভারে হোল্ড করলো।
Now, which action has been challenged here? Gradation list and other, they are the beneficiary.
No, they are
They
KMDA
will be
employees.
benefited if I succeed.
Huh?
They will be benefited.
Huh?
If I succeed
Huh?
by your lordship, then they will get the same benefit.
They will get the
They will get the benefit.
appearing.
Automatically they will get the benefit.
How? It will be a common gradation list.
Common gradation list for the engineer employed under Kolkata Metropolitan Development Authority.
And the KMDA.
Whether,
So how?
whether they are the original appointed by Kolkata Metropolitan Development Authority or has been transferred from KMWSA after merger.
Question of transferring does not arise if the merger happens.
Merger.
With the merger,
After
question of
merger,
transfer
they have
doesn't
become the
arise.
employee of Kolkata Metropolitan Development Authority. Moot question is this, whether a gradation list will be prepared on the basis of the merit in the selection test. That is
That was turned down by that was by
Justice Sinha, but approved by Justice Bharadwaj. And
now who are they?
They are the person.
They are the employees of KMDA.
Neither party in either of the matter. They are not the parties in either of the matter.
So what is your grievance, sir?
Lord,
Why
my
do you
grievance-
want to get added?
I have in
Get
my
the benefit.
application paragraph.
Get the benefit.
My lord, if they succeed, we will lose, my lord. My lord, we have something to say, my lord. I have stated in my paragraph.
How will you lose? Common gradation list you are opposing.
No, my lord.
No,
Then
most probably in common gradation list, you have been placed as senior at the top of the
Yes,
list.
yes, my lord. We
Of
are
being
supporting
existing employee.
we are supporting the action taken by the KMDA.
Yes, I am for the existing engineer, employed engineer.
Yes.
Engineers.
So existing engineers have been placed at the top. And those who come from merger,
Yes,
they
my
have been placed at the bottom.
My lord, my
It is that.
My lord.
No.
It is not.
According to the merit list in the year
Look,
2010,
seniority.
some of the persons succeeded in the test, joined in Kolkata Metropolitan Water and Sanitation Authority. Some of them joined in Kolkata Metropolitan Development Authority. After merger, all of them has become the employee of Kolkata Metropolitan Development Authority. After merger, what happened? The persons has come from Kolkata Metropolitan Sewerage Development Authority have been given promotion according to the old promotion policy. So they are getting benefit tens of hours for those who are initially employed in Kolkata Metropolitan Development Authority. Whereas merit list is a singular merit.
so you have been added at the bottom.
Yes, yes. Even somebody has superseded me. Because I
So
just,
how your presence will be, your claim will be ventilated by KMDA.
My lord,
Proper party is the
my lord, if I'm,
as per.
if I'm,
No,
if I'm allowed to,
ওদেরকে তো respondent করতে দিতে হবে।
Very applicable. মানে change.
if I'm allowed to,
There is the adversary effect.
ওরা উপরে আছে।
ওরা উপরে আছে।
ওদের প্রেয়ার হচ্ছে আমাদের পিটিশনও ডাইরেক্ট হবে।
My lord, our main prayer is that we should be, our seniority should be reckoned from the.
In connection with the writ petition, two applications accept your submissions, hear your submissions.
But if
If KMDA agrees, because there is no employer-employee relationship between them, with you, whatever is to be done has to be done, notional benefit, etc., will come. You are no longer their employees.
Yes.
my lord, while my lord will be deciding this question whether common gradation list is required to be formed or not, my lord, at that juncture, my lord, I may also have something to add. My lord, I may have something to make my submission.
You consent, we give pass them. We will add them as part.
We cannot give consent, my lord, and in my respect to submission, this observation cannot give them any cause of action.
You are not
They unnecessarily the
Unnecessary it will be.
Exactly.
Now,
if you are opposing, Mr. Talukdar,
Madam.
you are the employer.
Yes.
Whichever way the court directs, you will act.
Yes.
So if they are ultimately added, if you give a consent, how that will prejudice you?
My lord.
It is an issue. Your advocate general is with you.
Yes, he is
Please
reading me.
talk with him. That
I
how
will talk to him.
you will talk, and if you find that you are not, it is on consent we will give. I mean, if you say that I will not give consent, then the issue becomes a bit dicey. We have to go into it. We cannot create a forum for them. It is a very anomalous situation which has arisen, but it is ultimately the benefit of the employees.
That's true.
So you will act as the court directs. So today, if they are added, suppose the combined grading list is prepared. If they are not parties, you will totally exclude them. Whether you can do so, because it is a stale issue now, stale issue. Everybody retired, no relationship, দুটো কোটে ঘোরাঘুরি। আর আমরা হয়েছি।
And everything to be
Take instruction.
I will have to take instruction
our
from my
officer.
authority also.
No, you are our, forget about that. You are our officer. What KMDA will give you legal advice?
Certainly not.
My lord, you talk with the advocate general that the court is minded, is observing such. If we give a formal, or if you say that no, we will record you are not opposing the pair vehemently and add them everybody, and
Then let me talk with the learned advocate general.
এতদিন হয়ে গেল, you
My
couldn't
lord,
talk.
may I say on submission, my lord, in the meantime, what happened? Denying the order or the inbuilt procedure as has been held by Kolkata Metropolitan Development Authority in meetings regarding promotion. Promotions are being given superseding the petitioner's before your lord.
You are in employment.
I am in employment.
All of them.
You are in employment. When is your retirement?
Retirement is long. But
So doesn't matter. If ultimately we direct in your favor, automatically you become
then
entitled.
your lordship is to pass the order if I succeed.
That we will think.
My promotion will be given with retrospective effect. Then get the person who has-
Have we stopped you? Have we stopped you from arguing that? কবে একটা ডেট আছে দিয়ে দাও, by that time উনি নিয়ে আসবেন।
My lord, so far my application is concerned, I think they will not object.
I don't know. Let me take a
কি
video.
বলে দাও?
You are in service.
No.
Yes, will.
In respect of their application, we are not opposing because they are the fresh
That will be
candidate.
allowed.
Mr. Talukdar, it is understood that if you don't oppose, we will formally add them and we start hearing Mr. Sarkar. Already much time has been spent. We are fixing a date. You take the formal instruction. We will pass a one-line order. They will be added and we start.
Correct.
26 na কবে আছে না date?
Your lordship, kindly, I am repeating, kindly keep it in mind. In spite, if
No, we will forget.
so I am not prejudiced in my promotion.
We have a right to forget also.
কবে সুবিধা হবে আপনি বলুন।
আমার any day,
25th 2 p.m.
as their lordship will.
25th 2 p.m.
25th to 5th.
25th March.
March.
Let it be parted, my lord.
It is পাঠান না?
My lord, let me get part.
ভালো দিন আছে, মঙ্গলবার ভালো।
হ্যাঁ?
Part hard, let it be the
Assigned
part.
to it.
আরে
it's
পাঠান
assigned.
Part hard কেন? Assign. This is assign method.
Assign,
Yes.
yeah.
অ্যাসাইন করেছে তো।
Part hard এর দরকার নেই।
না অ্যাসাইন তোমাকে করেছে।
Assign.
এই পাঠার করেছি অ্যাসাইন to
I can assure your lordship, I shall not take much time. I shall not take much time.
করিনি
Okay, on that.
পাঠার পুরো দেবো।
না না
Choice is yours. We don't know whether determination will change or not.
Keep it in part. Let it be part. Let it be part. Let it be part.
Yeah, Mr. Talukdar, actually, they will be affected.
We have extensively heard Mr.
What are
Sarkar,
the-
learned advocate,
Both of them will.
in either way.
Main
appearing
problem is
for
where I've
the,
lost. I'm coming again to hesitate my around the way. I'm coming to hesitate my point.
you are
To
read
get very-
petitioners in WP number,
6688 of 2022.
Mr. Sarkar. We have extensively heard Mr. Sarkar, learned advocate, appearing for the read petitioners in WP.
6688 of 2022.
It is WPA or
WPA.
হ্যাঁ?
WPA.
WPA করে দিই, হ্যাঁ।
And
The
there
matter, the list the matter for further consideration on 25th as fixed at 2 p.m. Stop. The matter shall be treated as heard in part. Yes.
My question is simple.
Yes,
Follow
call the
the
next
regulator
matter.
followed by KMK as well as West Bengal government.
Okay, দিয়ে দাও।
Say it, gradation list will be framed on the basis of merit. So I'm paying for that.
ডাকো supplementary ডাক।
Grateful one.
I'm grateful.
Item number?
Item number 7, I'm appearing for the petitioner in this matter.
হ্যাঁ। This is suspension challenge করেছিল।
This is my affidavit of service, madam. This is, we are for the
My lord, I
proceeding.
am,
Give us 2 minutes.
Yes, yes.
my lord, I am for the respondent number 3 and 4. Learned counsel Arindam Banerjee sir is not here. His legs are busy in some other court. I'm taking a short passover.
Passover,
Fixed any date.
urgency.
কোন order-টা? Alright. You're coming against which order?
3 orders, I have challenged. Lordship will kindly take, all the orders have been, Lordship will kindly, I have annexed the certified copy, 9th January 2025 order, and my lord, 24th January. Yes, my lord. 11th January 2024 order, and also there is an order on 27th February 2024. I am aggrieved by that. I was not heard in respect to substitution application which was setting aside abatement, my lord. The legal heirs were not served. On the day, my lord, one of the junior prayed for an adjournment. After prior notice to 15 days, my lord, the honorable judge, my lord, has not listened to the adjournment and passed an order without recording a single statement, my lord. What was the ground for delay for condonation, and nothing has been given, my lord. The proceeding has abated, my lord.
14th of which order?
Yes,
you
Lordship
are
will-
coming up against which order?
Lordship will kindly take, my lord, for your lordship's kind consideration, my lord. Lordship will kindly take, my lord. Past order, yes. 27th February 2024 order.
কি করুন শ্বেত? So come next Monday. Tell you.
Lordship will take it on Tuesday, my lord. Only one urgency, the 13th is a date fixed, my lord. We have already filed a recalling, my lord, that was not accepted, my lord. 13th is a date fixed, my lord, so that
If that has not been accepted.
yes, we have filed it, my lord.
13th is
Yes, my 13th is the date, my lord.
You will just say this point before the.
Yes, yes. Lordship will kindly takes the 9th January order.
You have filed recall application, recalling, and side by side you are challenging the said order.
No, my recalling, my lord, I have placed it The Honorable Tribunal has said we will not hear the recalling, we will go with the section 5. Our contention is that, my lord, if today the recalling is allowed, and if this abatement, which is, my lord, if the substitution application which has been, my lord, order has been passed without considering all the delays and everything, if that is set aside, how the section 5 can be, my lord, moved? On that score,
No, we don't follow. You are the respondents in the.
oh, yes, my lord, I'll just give a short background, my lord.
No, sir. We are asking you, tell us. What application did you file? MA1?
Like their application, that is their application.
Acha, why you are aggrieved? You
I
filed
was
what?
aggrieved, my lord. There were certain, my lord, there are deaths of the Thika tenants, my lord. Original proceeding. In original proceeding. Now, my lord, what has happened, my lord? We have given all the details. Now, my lord.
Sir, what application did you file?
Well, I have filed a recalling of the order on the basis of which the substitution has been allowed without recording, my lord.
Wait. That substitution application is what is the number?
Yes, my lord. Lordship will kindly seize, my lord. That is at MA 814221. Lordship will kindly takes it note from the order itself, my lord.
5 of 2081.
No. Phone order. 814 আমি দেখেছি কালকে পুলিশ Lordship will kindly takes, my lord.
MA 814.
Yes.
Just give us time. Substitution.
আরে এইটাই order
So substitution was allowed. Your substitution was allowed.
Their substitution was allowed, man. I am on a very
But the original applicants.
No, malad, that was why section 5(3) of the Thika Tenancy Act, malad, they have filed a proceeding before the Thika controller. We are the Thika tenants. We are living since last 50 years. Now, malad, they have filed a proceeding, malad. That proceeding itself was dismissed. Now, malad, on the basis of the dismissal, malad, the learned controller took out all the applications which has been filed by the Thika tenants, specifically recording who has died, what is their legal heir's name, and how the right has come as a Thika tenant. All these things has been given in the original order. Now, they have filed that order before the tribunal. Now, while they have filed the before the tribunal,
means challenge the
yes, challenge the order. I'm sorry, challenge the order before the.
They are the owners.
No, they are claiming to be the owners. Now,
Right.
our defense is that the state of West Bengal is the owner.
Now, this Thika controller order,
Yes,
by which your names were substituted,
yes,
that was challenged before the tribunal. Main order. Main order
no.
was challenged.
May I correct myself? What has happened? There were 100 of Thika tenants. Now, some of the Thika tenants died prior to the filing of the appeal. Some died in 1885. We pointed out this for the first time before the tribunal. See, they have filed a proceeding against the dead persons. This cannot carry on. On the basis of that, also we have supplied the name of the legal heirs. The Lordship knows,
So, what application did you file?
But we did not file any application. We just intimated through our letter. They filed a substitution application for setting aside abatement. Now, our contention is that.
Then what did the tribunal do?
The tribunal, on a only one-page order, without considering that, if a person dies, prior to the filing of the appeal, so his name is cannot, a dead person. How can you file an appeal against that? If a legal representative has to be brought into.
Very difficult to proceed with you. We are asking the question. Please answer that question. Then you make your argument.
Very well.
Then what did the tribunal, that one-page order? Which is that one-page order?
That one-page order is the 27th February 24 order.
27th February
2024 order.
So that substitution was allowed.
Yes.
Then what happened?
We filed immediately a recalling application. Why? Because we
recalling of this order of 27th February.
Yes.
That application is MA2 of 2021.
Our application is, my lord. Our application is, my lord, M8. No. Last date. That is MA. No. MA2 of 2021 is the section 5. Our is 509 of 2024. That is on the last order, my lord. Lordship will kindly seize, my lord.
Section 5 was filed in connection with the
appeal.
Yeah. Now you have 509 application you filed.
Yes.
For.
Lordship will kindly takes 27th August order. We have specifically mentioned this appeal in the middle of the
You
part.
application you filed for recalling the order of 27th
yes.
February.
Yes.
Now that has been fixed for hearing on 13th.
No, not this application. We prayed before the tribunal. This application has to be heard. The tribunal has specifically directed us. No, we will not going to hear the recalling
Where
application.
is that we will not hear?
That has not been recorded.
So go and agitate all this before the tribunal.
They have said before to come before this honorable Lordship will kindly see.
Oh, they will say and you will come.
Lordship will
You
kindly
will
see the
not ask
order.
the tribunal that pass an order, record that.
Lordship will kindly see what has happened.
What is the number of your recalling application?
My is 509. Lordship will kindly takes. I have annexed it. 9th January 2025 order. Lordship will kindly seize.
না ওটা না or 9th order 9 January যেটা 13 তারিখ রেখেছে ফার্স্ট অর্ডারটা হ্যাঁ উপরে দেখো 5
So
you will make this argument which you are troubling us before the tribunal.
I have made it. Lordship will kindly seize the order. Lordship will kindly seize the order.
Yes.
9 একটু 2 মিনিট দাঁড়া 9th January 2025 order.
Yes.
Lordship will kindly read Mr. Surya Prasad Chattopadhyay, Learned Counsel, along with Mr. Arjun Samantamala, appears for on behalf of respondent number 333 and 47 to 50. Mr. Rishabh, 9th January 2025 order.
Yes.
Now, my lord,
appears for the on behalf of respondent number 9.
Yes. Now, my lord, learned government representative is present. Today is fixed for hearing of the MA number 2021. Opportunities given to the Thika controller for submission of affidavit in opposition against MA 22 of 2021. Leaves the matter on 13th March. Now, on the just, my lord, Lordship will kindly turns the page. On 27th August 2024, we took out the application mail and we have placed that, but the Honorable Tribunal has not considered that. Lordship will kindly seize, my lord.
MA2, the application for what purpose is was filed?
My 2 of 21 is their section 5 to the original application, to the appeal. They have preferred before the tribunal. So that is pending.
So when numbers of application has been preferred before the tribunal,
yes,
tribunal has given priority to the hearing of the section application, section 5 applications. So what wrong tribunal has done?
My contention was that, my lord, that the substitution application.
You are anticipating, sir. You are anticipating that tomorrow my application will not be heard. Condonation of delay will be allowed.
And not anticipated, man. Not anticipated.
Then you come after 13th, you make that prayer before the tribunal.
I have made, my lord. What Lordship will kindly seize on 27th August order. We have filed it and the tribunal recorded.
Who is disputing that you have filed?
They have fixed for hearing of 2 of 21. So if they have fixed for 2 of 21, so my 509 cannot be heard, my lord, first.
Come to the top of the page.
Yes. MA 02815 502, because that was tagged with the record in respect to the previous order.
Say that your writ petition is a misconceived one, we will dismiss it.
May I submit?
We will dismiss it.
I have challenged 3 orders. I have challenged 3 orders.
We are not concerned. 13th is the date fixed. You have to go to the tribunal and avail your remedies. We cannot keep the matter pending and say that let us see what the tribunal does.
What has fallen from your lordship, I bowed on. But the practical difficulty, what I have personally faced before the tribunal.
We will observe. We will say that the petition is misconceived since we are unable to accept your submission that the tribunal has declined to hear you.
Let them say, the tribunal has not done so. The tribunal has specifically stated that order has been passed.
Sir,
it is not challenged before any honorable court.
Show us where tribunal has said that I will not consider.
But this is something they have fixed on. Lordship will kindly seize.
Has been preferred.
Lordship will then kindly direct that this application, my application may be heard fast out.
You will say
because I am challenging that substitution application.
If the section 5 application, 1 minute, Mr. Baj, if the section 5 application for condonation of delay in preparing the main petition goes, everything goes.
That is and they
you are taking that substitution abatement in respect of one particular party.
Not one particular party.
These parties represented
50 parties are there, my lord. Lordship will kindly see there was an order of this honorable court. Justice Harish Tandon has specifically stated.
You want to withdraw. or we dismiss your
Well, I'll not wait. Well, Lordship will kindly, well, give me a 2 minutes time. Why I'm
we have heard
praying
you.
before your
We
Lordship?
have heard you. We have
Well, 9th January order. Well, 9th January order. Well, what has fallen from the Lordship? Well, we have specifically stated before the tribunal. Well, kindly hear our recalling application.
Please listen to our order. Then you say.
My lord, may I
The
give your
present-
lordship
sorry.
half a minute?
Present writ petition has been preferred. Challenging inter alia
27 is my answer.
Don't say.
But 327 is my answer, my lord. Lordship will kindly cease, my lord.
Nowhere you just prove that you have a connection of any person whose name referred in this order dated
Malam, may I-
2nd February 2020.
Malam, may I take your lordship's 2 minutes of time? Malam, in a single proceeding, my lord, all these, there are A, B, C, D, F, all premises,
You have
all these are
stated-
community.
You have stated this thing only 15 times.
Yes. Now, my lord, all these
Give
persons.
specific answer how you are connected with this person.
Yes. Malam, we are representing them, malam, because the lordship will kindly.
Who are they? Who are they?
Malam, we are all residing in a.
Are you party to the proceedings? And you are not party to the
Yes.
proceedings? Where?
Yes.
Show us in the original application your
Sukumal
names.
Pal.
Huh?
Yes. Yes, malam.
Where is that?
Malam, at page 36, malam.
Many persons have to You have no right to challenge it.
সবাইকে মানে we have specific letter has been given my lord to
Where
Sukumar.
is your
Yes, Sukumar Palta.
Yes.
Yes, মানে page 40 my lord, page 40 my lord, Shormila Pal 44, Malati Pal 43, and all are there, man. We have even the
One moment. We are wanting who are before us.
yes, Sukumar Pal.
Malati Pal 53.
मतलब 53,
59 Sukumar.
59 is Sukumar Pal. 53, 59 of page 41. 50
Legal heads thereও আমরা
আমি জানি এটা জজ সাহেব চাইছে বলতে
Sukumar Maloti Rupjhar.
yes yes
others are performers.
মানে everybody is performer.
Now you answer my brother's question.
yes yes মানে today মানে what has happened মানে this is the
If the legal heirs of this person
How you are
substituted,
how
you
you are
will
problem?
take it?
my lord
How
all
you will
my lord not in my lord respect to myself only my lord we are this Sukumar Pal and these 4 persons they are representing the entire community of all the tenants. They have
you are
given
leader.
my lord
Oh, you are leader.
no he is not a leader he is a very
We have to forget the CPC or
no
any procedural law
my lord
since you have assumed the leadership.
no kindly don't take me a miss my lord I am only
How we
trying
are
to my lord
connected. I am talking about order 22
yes
and everything. When
I am on a
approve the
specific
question, taking
Well,
responsibility.
today I am taking the responsibility because all this has been directed in respect to one single proceeding. There are not 50 proceedings. In a one case, my lord, all orders has been passed. And my lord, Lordship will kindly take the order.
A person whose name has been referred to the
We are representing, my lord, Lordship will kindly cease. We are representing them. Lordship will kindly cease. This is recorded in the order. This is recorded at least for 35% we are representing. And my contention was that there are also rest persons. Service was never
Not
effective.
being able to find any right of yours to challenge somebody else's substitution in a proceeding.
Not in respect to a
Please,
substitution.
please. We are not in a position. We have heard you. We have given you enough opportunity. Now we offered you that do you want to continue with this or you will make your argument on 13 before the trial?
Lordship will kindly then observe that that my application may be hard on merits. My application
we
for
don't
recalling may
find
be hard on
anything.
merits.
we do not
If a lordship, I'll come back with a judgment in that case, my lord, that in a dead person, if a suit has been filed against a dead person, my lord, lordship knows that, then in respect to that person's, my lord,
Your application has not yet been heard.
my
If you want to get your application heard, you have to withdraw this petition and argue before that. Make your submissions. And if they make any comment, that will give you a further opportunity to come to us.
only
Now
one
choice
thing,
is yours.
very well, what has fallen from your lordship, only one point your lordship will add it. Lordship will only one add, my lord. Lordship will kindly give some preference to my application to be heard, before their application.
Present petition has been preferred
telling Mr. Chattopadhyay not to make any.
No, I am not on a, but submission lordship has recorded, my lord. Lordship will kindly record that, my lord, what I have submitted. My lord, I am on a,
Record what?
my lord, I am not against the substitution of the legal layer. I am on such thing.
Did for half an hour.
My lord, substitution has been done, my lord, without giving any notice to any years. Who has died?
My lordship,
Yes.
my lordship, I'm for the state
Lord,
responding
may I-
to
Lord,
this
may I-
matter, lordship.
Good after the
My lord, no service has been done. My lord, that is also my record.
Milord, may I, Milord, accept my humble, Milord, my kindly accept my apologies, Milord.
Yes, call the next.
Oh, call.
Please accept, Milord, my apologies. It was not intended, Milord, to offend your lordship. Kindly accept it.
Yes, yes.
Please, my lords.
Item number 8.
Last occasion, I requested your lordship kindly hear my junior. I wanted to go away from this matter because of something happened which I didn't like. So lordship kindly allow my junior to make his submission. I'll be here.
No, you argue. What is the problem?
The matter was, my lord, came before your lordship, and by an order.
Yes, what is
17
the, this is item number 9.
Eight.
8.
Yes.
Oh, what have you challenged in this?
I have challenged order passed by the learned single bench. They have challenged.
No, this is a, what is CAN 1?
CAN 1 is my stay application.
So, CAN 1, where is the order? Which is the impugned order?
Page 183, my lord.
Paper book আছে নাকি?
No, this is, my lord, first time it is coming and the application heading. There is no direction for paper book. Now,
what you are saying?
But I was just assisting my lord with the page number only thing. That is-
180
I'm the respondent.
180
ফাইলটা দাও না, অর্ডারটা কি করে বের করব? এখানে দিয়েছো এটা?
Before, my lord, placing the order, impugned order.
This is coming for the first time.
Not first time. It was first came before your lordship on 17/12/2014.
Who are you appearing for?
The
Petitioner, respondent.
All right.
And that
Who
order,
was the impugned order?
page 182.
180?
182.
This was upon affidavits.
It was not on affidavit. The court has asked for report. We have submitted 2 reports. On that basis of that report, that was.
Where is, you have annexed those reports?
Those 2 reports was annexed. I have
So
annexed the petition.
did they use any exception to those?
Yes, they have used
So
exception.
there is no question of any further pleadings in this. Huh?
No, man.
So we direct preparation of paper book and hearing of the appeal.
The only thing, my lord, since everything is on record, my lord, subject to your lordship's convenience, my lord can
He
hear out.
used to do that, but it will be difficult. 2 reports are there, your exceptions are there. He will file the composite.
Only one thing, my lord. Only one thing may I enlighten that they have, my lord, taken a similar circumstances. Person have filed an appeal, filed a writ application against that, an appeal was preferred by us, the WBSC-TCL. That appeal was, my lord, dismissed. Against that, we prefer an appeal, prefer a review application. That review application was partly allowed, and against that application judgment, we prefer an appeal before the Supreme Court. Now, what is the stage of the Supreme Court? Today I don't know, my lord. Last occasion when that matter was taken up, my learned friend submitted that we have complied the order. On that basis, your lordship.
No. He said that similar matter, it appeared before Justice Sen.
Yes, and Justice
it
Sen
was heard
passed an
by
order, and that
did not say about Supreme Court.
No, he don't say this. He said that we have complied the order of passed by the Justice Sen. That's why we, my lord, your lordships,
forget about those things. Now, what happened? Did you file SLP?
Yes.
Against the earlier order?
Yes, division bench order passed by that.
By the division bench, what was said?
They have, my lord, directed to give the petitioner, that writ petitioner, for the interview.
So similar to this.
Similar to this.
So do you have any knowledge as to what is the fate of that SLP?
Special leave petition, I have to take instructions. I'm under instruction that there is no stay, but probably it has not been disposed.
Let us find out if there is any interference of Supreme Court. We will direct filing of paper books then.
Right.
But since it is a matter of interview, we will not keep it unnecessarily pending. If the SLP has been disposed of in whatever manner, please inform us.
It will kindly give me tomorrow.
Then we can proceed with the hearing of this as to whether this direction is certain. Finished.
Right.
Yes. Yes.
Right.
When will you come tell us?
My lord, next week I shall, my lord.
Please make up your mind and say we will finish it up on that day.
Yes, my lord. But that if the
SLP, Mr. Roy, it was pending since 2013.
Yes.
You don't know when the SLP was filed.
No, that the last order, my lord, that review order was passed on, my lord, 20th September 2024.
Against that order, you went up to SLP?
Yes. And that order was supplied on January 2025.
Next Thursday. Come with the
present situation, I shall inform.
Obtain a slip and give it to us. If there is order, we will direct paper book filing, or we will fix a date and finish it. Deeply. Who is your other side?
Instead of tomorrow.
Oh, Monday is a combined list. It won't be there. The combined list is there. First matter is suspension. The Mongol word.
Lordship, item number 9, the next matter, item number 9 and 11, I am appearing for one of the parties. I will not be there tomorrow. There is a doctor's appointment, your Lordship. If your Lordship, any date subject to your Lordship's convenience.
Idea you have stopped coming.
No, your Lordship, I have a doctor's appointment. My wife has a doctor.
Item 9 and 11.
9 and 11.
Who is your other side?
In 9, Mr. Shommo Mujumdar is appearing for the respondents. I am the appellant. And in 11, I am the respondent, and Mr. Tanoy Chakraborty is for the
No,
state.
11 is State of West Bengal again.
Yes, but in that matter, I am for the petitioner respondent.
Have you taken consent of your friends?
No, your Lordship, I will inform them because I did not know whether your Lordship will take up the matter today or not.
All right, next Wednesday.
I'm grateful.
10 and 11.
9 and 11, your Lordship.
9 and 11 to next.
I will inform my other side.
If
my
any
respective-
problem, don't embarrass us.
No, your Lordship, I will immediately inform them. I will immediately take steps.
Only thing, item 8, if my lord is pleased to pass any order, my lord deems fit. My lord has probably adjourned it after 7 days. If my lord passes a one-line order.
Mr. Rai, what you are saying? In a similar matter.
Yes, in a similar matter, another writ petition was moved. What happened in this case? They have challenged the process of selection.
SLP, you have preferred against which order?
Order passed by that on my lord.
SLP has been preferred against which order?
That is my lord 20th September 2024.
This is annexed to the petition.
No. This is not the another set of writ
What
petition.
order we will pass, sir? SLP.
This is the order from
We have
which
kept it next Thursday so that you can.
as my lord deems fit. As my lord deems fit.
So you want a recording of your appearance?
No, my lord, as my lord deems fit. As my lord deems fit. I cannot.
In course of hearing, Mr. Royal and